Okay, good morning, everybody. We just have been talking down here about the fact that it's a good thing we have a 10-minute rule. You can start the meeting 10 minutes late. So here we go. We're going to start, as usual, with Mimi taking roll call.
Okay, Justice Edmond?
Here.
Toby Rothschild?
Here.
Joyce Raby?
Here.
Andrew Rita?
Here.
Evan Bowden?
Here. Here.
Tara Bird? Here. Judge Wendy Chang? Abhijit Sivan? Jean Clausen? Johan Volkswagen?
Present.
Margie Estrada? Lori Gonzalez?
Here.
Bridget Grammy?
Here.
Andrew Kuchera?
Present.
Joanna Mendoza?
Here.
Kevin Moore?
Here.
Heather Morris? Alan Rodriguez?
Here.
Dan Rubens?
Here.
Mark Tuft?
Here.
Angelina Valverde? Joshua Walker? Thank you.
All right, thank you all very much. This is the time that we open up the floor for public comment. Is there anyone present or on the telephone who wants to participate in public comment? All right, hearing none, we're going to move on in the agenda. The next item is the chair's report, so it's going to be very, very brief. Let me first say Happy New Year. As I recall, we were together about a month ago.
It seems like a decade before.
And I gotta say, I don't know about you, but it was like the fastest month on record. So I appreciate so much you all being here again today. I appreciate all of the effort that you all put in between times when it was the most hectic time of the year to get us to this place. So thank you all very much. Having said all of that, I think it's fair to say that we are now in the home stretch. And we really need to accomplish a lot between now and we have 2 more meetings left. That's it. The 2 meetings, just so you know, are currently scheduled for February 4th and February 24th. And then this is all shooting for the goal line of the Board of Trustees meeting, which is currently set for March 12th. It is not entirely clear whether or not March 12th will be the date that they actually take up the issue of adults, or whether they do a special set, perhaps sometime later in the month. If it turns out that it's March 12th, we're probably going to stick with those 2 days, February 4 and February 24, in order to get everything ready for that March 12th date. If they push it back later, we might buy ourselves a few more days. And so the February 24th date might be a bit flexible. We might try to get some additional time between those 2 meetings. But otherwise, that's really what we're looking at between now and March. And so I think it's fair to say that time is of the essence, that we really ought to focus today on trying to reach a consensus on anything that we can so that things can move forward as we look really toward the end goal of getting this to the Board of Trustees in March. Finally, let me say congratulations, or I'm so sorry, to Leah. Leah, as you probably know, has announced that she's going to leave the State Bar as Executive Director. The good news is, the only good news about that for us is she's decided to stay on with us. And so we appreciate that so much. You have contributed much to this group, and the thinking and your good judgment, we appreciate will continue, and so thank you. Anything you want to say to the group?
No, just thank you for your kind words. I'm sorry you're surprised, Joyce. I really got some back and forth over the holidays. I felt to mention it to you. No worries. But I am excited that the board has asked me to stay on in a consultant capacity to work on a number of projects, including this one. So you'll still be seeing me.
So thank you. And then congratulations to Donna Herskowitz, who's going to be the stand-in for Leah as the acting executive director. Do you want to say anything?
Just that I too am very glad that the board has agreed to have Leah stay on in a consulting capacity on a variety of projects, including adults. So we will all be spending some time with her in the months to come.
Wonderful. So I'm going to turn this over to Randy for the specifics, but you all, I know, have seen the agenda and what we're going to be talking about today. We're going to be talking about initially are there rule approaches that we think are appropriate to take, but then also, ooh, is that a hand?
Yes.
Yes.
I just want, is this working? I wanted to see clarity from the board that we should book flights for February's meetings. I know that we were told to wait, but should we go ahead and book those?
You should definitely book February 4th, and I would, if you I kind of think we should book the 24th as well, because right now the game plan is our final deliverable is going to the board in March 12th, and so unless that changes, we are a go for 4th and 24th.
So book both of those flights.
I think that is prudent.
Thank you.
Okay, thank you for that clarification. So we're going to be talking about the various topics that we've actually been talking about since November and deciding what makes the most sense in terms of what direction we ought to take, whether we take a rule-based approach, whether we then, at the last meeting, it became pretty clear that there's a lot of division among the group about if we take a rule approach, what it'll look like, and so perhaps the consensus seemed to be going at the last meeting that perhaps we ought to be considering a sandbox approach, and so we'll be spending a lot of time talking about that today. And at that point, I'm going to turn this over to Randy to talk about the specifics. Good morning, Heather.
Good morning, sorry, I'm late.
No problem.
So for the staff report, I don't have much in the materials. I included a January 8th article from the Artificial Lawyer, and it's a publication, I guess, called Artificial Lawyer. And Joanna, I guess you were at CES, and you can assure us that there are no artificial lawyers being pitched for the market, at least not yet. But this article confirms once again that there is a watchful eye on everything that we do, and they are eagerly anticipating what we recommend, and they even sort of teased the fact that they are looking at the fact that we will be talking about things like sandbox today. So just look at the article if you have a chance. The plans for the next meeting, February 4th and 24th, they're both in Los Angeles, just a reminder. Draft final report and recommendation language should be prepared for consideration at the February 4th meeting for the competence rule comment recommendation, which was voted out at the December meeting, and staff will take the lead at doing that. And for a UPL exception, the human or non-human tech or sandbox recommendation that might be voted out today should also be assigned out. I don't want to get ahead and say there's actually consensus on any of this, but if there is and things are voted out, then the assignment would be to prepare what would be the text that would explain it in the final report, how it advances the charter, what are the pros and cons, what were the alternatives considered, so that we're not building the report at the last minute. We will also have an opportunity to discuss non-lawyer ownership and fee sharing. Again, if something's voted out there, we would make assignments to do the further write-up. Also on our agenda, though, is 5.7, AGA Model 5.7 on non-legal services, and the advertising rules. And they've taken sort of a back seat because we've been starting with the two biggest ticket marquee issues, UPL exceptions and fee sharing and non-lawyer ownership, but we have to get to them today. Because if we want to make any progress and have anything written up for the next meeting to actually vote out to go into the report, we want to at least give those teams some feedback on what they've already submitted. Maybe we will be very fast and efficient and vote something out of those today, but we should at least touch upon them so that those groups can come back at February 4th with something that can be officially finally voted on. February 24th, I'm hoping we can reserve to actually look at the structure and content of the report that we're going to present to the board, because we want ABLE's members to be comfortable that it reflects the consensus of the body. We also want to talk about the game plan for the presentation for it. We'll be looking to leadership, but we may need other subject matter experts to assist in that presentation, the same way we did with the Rules Revision Commission, where leadership took the main role, but on certain topics it was important to have other people who have the expertise present that to the board. So we'll be hopefully at the last meeting, that February 24th, all done with what we voted out, and just talking about how we're going to convince people, persuade people that this is all really good stuff. At the January 23rd meeting of the Board of Trustees, which is in Los Angeles, there will be a planning session that will include a section on triple LT programs. Now, you might be wondering, well, why are they talking about triple LTs when that's sort of what we're talking about too? Even though we don't like the word triple LT, it's a bad word. I learned at the last meeting, I guess. The board has always had on their strategic planning document, even before ADLS was created, triple LT. And if you read the history memo that was on the agenda last time, you know the State Bar has been looking at it for years. But they will be talking about it, and let's say they're interested in it. Let's hypothetically say they even want to consider a working group. Anything that comes out of ADLS about non-lawyer exceptions, paraprofessional, new licensees or providers that might be in the category of like a triple LT, my anticipation is that that good work, that good analysis, that recommendation would be referred to the board, to whatever working group they might create that would be the implementation body for that reform. So we shouldn't stand down. We shouldn't feel we're cabined in any way by what the board is looking at. We're still free to make our own recommendation, and the board is operating on a parallel track and will likely be having some good implementation forum for that recommendation to be fully considered. The presentation will include a representative from the Washington Triple LT program that will give a detailed look behind the curtain at their experience. And the planning session on the 23rd is actually going to be live streamed. So if anyone on this task force is interested in actually seeing what the board discusses and the Washington representative's presentation, you can watch it on the webcast. Last thing, staff reported at the last meeting that we were trying to work on a survey, and Leah alluded to it, that work has been done on a survey. Thank you to Joyce and the other members who worked directly with Leah in December in trying to get some ideas to the National Opinion Research Center and the University of Chicago, NORC, who is actually constructing the survey for us. There will be a survey. It will ask the survey respondents to give their views on use of technology, access to technology for solving problems, with a specific emphasis on their experience in looking at legal problems and issues using the internet. Our game plan is that we will have a final deliverable from NORC by February 28th. I think that's still correct. And that will be too late for us to consider, but the timing will be perfect for the board to look at the responses to those survey questions and compare it to what we are saying in our report. And if the survey responses are similar to what we've heard from speakers who have conducted their own surveys, Dr. Sandiford, et cetera, I can't predict, but I think things will probably dovetail well with what is being recommended and the sense of the public, what is accessible to them, what they're interested in using, what they're willing to use. But we'll have to see.
And Randy, I would just add, based on our experience working with NORC on some other studies just last year, I would anticipate we'd have a very comprehensive rough draft of the results in time for the meeting on the 24th.
Oh.
Because they do share findings along the way. So certainly there will be information for this group to consider.
So Randy or Leah or anybody else who knows anything about this, can you give us a little more information about who's going to be surveyed, about what kind of population we're talking about? Is this something that happens over the phone? How is it going to be done?
Let me pull up an email that I got from them.
Turn your mic on.
Yes. Let me pull up an email that describes this. So So NORC has these panels, they're called the AmeriSpeak panels. And the way that they get it is they take a random sample of addresses in the United States, and then they're representing the United States at a state level, meaning proportionally. So we have a California specific sample. The invitations are sent by mail, and they try to match the population on a demographic basis. So race, gender, income, and geographic, whether you're classified as an urban or a rural household. So that's how they get their panels, their AmeriSpeak panels. I talked to NRC about our interest in potentially oversampling certain populations. So their standard mode of operation is they give us a sample that reflects California demographics, but we can oversample certain populations, like if we want to oversample low-income Californians, if we want to try to oversample rural, although it's harder, if we want to oversample Spanish speakers. So they do have a large number of Spanish speakers in these panels. It's more difficult to get other non-English speakers in the panels. So that's the set of questions we're grappling with now is who, and I want to touch base with some of you on that. But that's how they get it. They send out invitations to randomly identified folks all throughout the country. So they have tens of thousands of people on these panels. This particular survey they plan to send out to 1,000 Californians. And they do it by phone.
Last thing for the staff report is kind of just jumping ahead because I don't want it to get left unaddressed. At the end of our agenda, D2, we were going to talk about the informal forum for stakeholders, members of the task force that Bridget has been our lead on, and I think she can report on an upcoming meeting in San Diego in late January with law enforcement and legal services stakeholders.
Yes, so right now confirmed for next week, we're gonna do a roundtable with consumer attorneys. And then at the end of January, they have this kind of monthly or quarterly roundtable with, the Attorney General, it's in California, or the Attorney General of California, plus the DA in San Diego, and then several legal services groups. They talk about consumer protection issues, so I was able to get on their agenda, so we'll get some, I mentioned, we got some initial feedback from them that I wanted to get some more from them. So that's happening, and then we're still working on getting the legal services date and the legal tech dates.
Bridget, that's very helpful. Thank you so much for all your
And we'll definitely put on the agenda opportunity to transfer all of that, download all of that to us at the February.
Okay.
And that's all I have for that.
Okay, thank you very much. Just so everybody knows what we're doing today, you've got the agenda, you see what we're going to talk about, but Randy has sort of red flags for all of us, the fact that we've got to get to the end and we've got to make it all the way to the advertising list today. So keep that in mind as we go through our agenda. We are going to break for lunch at 12:30, so you have it in mind what we're doing, and we'll break from 12:30 to 1. At this point, we are going to turn to the approval of the action summary from the December 12th meeting. You all have that in your materials. Is there a motion to approve?
So moved.
It's been moved
I'll second.
and seconded. Thank you. Amy, you want to take a roll call vote?
Andrew Ruda,
Yes.
Simon Bomey,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang, Abhijit Sivan, Jean Clausen, Johan Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Abstain.
Bridget Grammy,
Yes.
Andrew Pichera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morris,
Yes.
Joyce Raby,
Yes.
Toby Rothschild,
Yes.
Ellen Rodriguez,
Yes.
Dan Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, Joshua Walker.
Yes.
Thank you.
Okay, I should have asked before we immediately jump back into the agenda if anybody had any questions for Randy based on his staff report. Hearing none, we'll jump right into the agenda. Discussion item number 1 is the recommendations concerning exceptions to the unauthorized practice of law, both on the human side and the tech side. We had a brand new report this time from Joyce and Tara. We thank you very much. And so I'm going to turn to the two of you for a presentation on independent paralegal
Yes,
proposal.
I'm going to do a summary, and then Tara, you can jump in if I get it wrong or decide you want to add some context or color to my comments. I will try to be as quick as possible. We abandoned the tier approach. We had some conversations with each other. Some of this came out of the last meeting. I also had a conversation with Leah, trying to make, I think we successfully created an opportunity to expand the practice of law to include a new category, but built as much as possible on existing educational, regulatory association, all the sort of infrastructure that currently exists for a paralegal. And we called it an independent paralegal. Tara and I both really hated the LLT or triple LT or LLLT designation, and felt like the independent paralegal was something that a consumer might understand as being sort of an expanded role beyond a paralegal. Most people seem to understand what a paralegal is. And so we went through and articulated the educational requirements. We articulated some of the ongoing continuing education requirements, their duty, some of the similar duties of an attorney. We took a lot of this material straight from the Paralegal Association website in an effort to sort of reinforce and not reinvent the wheel. We did have some commentary, which you can see from Kevin, that is included in the materials that you've been given. I mostly just, as a kind of a straw vote, just want to, in terms of creating a more streamlined, simpler, vastly, we think, more implementable idea versus our original idea of tiers. We also really appreciated being able to separate the tech from the human exception, because we felt like that it just muddied both of them and made it harder for us. And because tech was kind of closely associated with a couple of other recommendations, the fee sharing and non-lawyer ownership, and I think Bridget and Joanne both pointed that out last time, that just fit more neatly sort of under that umbrella, if you will. So nothing in here to me seems particularly controversial or scary. So I would like to just get a sense from the room, does anybody disagree with that statement or say that they do think that there is something in here significantly? Oh, Andrew, I was so close to just wrapping it up. I was going to do it in 5 minutes. Go for it.
On a macro level, I really like the idea. So I definitely support it. On a much more granular level, I maybe have some issues with the education requirements and what the independent paralegal is allowed to do, and things that I'm not sure when we take a vote and make a recommendation how granular that's going to be, because obviously the people in this room aren't going to identify exactly what those education requirements are going to be and exactly what the paralegal can do. So that's it.
Well, I'm not gonna let you quite off the hook. I'm okay with moving the specifics around educational requirements or continuing education requirements. I think there are certainly ample room for the implementation, or ADLS 2, I guess, is kind of the buzzword for whatever comes after this body. I'm a little. You said you had a couple of comments, and one of them was, not education, but really sort of what they're allowed to do. And I'd like you to expand a little on where your issue is on what they might be allowed to do, because I think that is something that is far more kind of the crux of what we're attempting to accomplish.
Okay, so on page 1, at the bottom of page 1 of the recommendation, that's where it describes what the independent paralegal would be allowed to do.
Yes.
What's left? In between what this person can do and what an attorney can do.
Tara.
I'm going to help you out
She's
here.
awesome. She's perfect in everything.
So, the concept kind of, I don't want to say we totally abandoned the tiers, because in my mind, we didn't. It's just that we needed to work in a sort of a different framework. But the idea being that there'd be some level, and and I'll grant it that it's not clearly identified even in my mind yet, but there'd be some level where a paralegal could offer these legal services, can actually provide forms to people, could actually, tell them, help them with filling out the forms, these types of services. But then they would need to specialize, to give additional legal advice, they need to specialize in a very narrow area of practice. They wouldn't be able to just do anything. Let's say it would be family law, and they would have to have special MCLE in family law. Maybe they will have had to work for a family law attorney, so they've developed a specialization. And again, I guess I don't really know how to answer where it ends. In my mind, it would end at going to court. I think that some people might disagree, and again, that's for the implementation committee. And I think it might also vary based on the area of practice. Something that we've discussed a lot, especially with public comments, is that every practice area is very, very different. Somebody helping a plaintiff with an unlawful, or a defendant with an unlawful detainer action, I think could probably take that matter much, much further than somebody helping them with a different type of action. So I think that would come down to the specific practice area, and I imagine this being developed, again, based on those areas of need and the area by area specific.
And I think the other thing I would add to that response, and if you're speaking, that may represent a client in court is kind of the last item on there. There is a question mark. We're not totally sure. I think the reason we left it open, when I think about it from Tara's perspective of the distinction between different practice areas, a lot of immigration work, and I'm not a lawyer, so please do not tell me why procedurally I'm inaccurate, because I'm sure I am. But I think that there are probably practice areas or opportunities where there's a big opportunity for failure if someone even properly prepared, goes into a courtroom without some assistance. And some of the other they've been called navigators and, are allowed to at least stand in court and respond to questions from a judge. They don't necessarily represent the client, but they can help the client respond and comply with the procedural aspects of court, which often are as confusing and trips up SRLs just as much as the how do I fill out the proper form. So I would agree that we could add some language maybe to address kind of your concerns, to talk about the different ways in which court representation, if that's one of the ones that jumps out at you, can be kind of constrained, or how we might define those parameters, or suggestions for ADLS 2 to define those parameters. Would that satisfy and sort of meet your concerns?
Well, I think the practice area limitation is a good and important limitation, but within the practice area, we still are now allowing an individual to create an attorney-client relationship, to give that client legal advice, both without supervision, and represent a client in court also without supervision. My question remains, what is it that individual cannot do that a lawyer can do within that practice area? Or are we creating like a practice area lawyer that can do everything a lawyer can do in that practice area? Because I don't see any other limitation in here.
I'm not sure I'm going to argue that. I think that we are attempting to open up for people that don't, in areas where there are currently no assistance being provided, a way for someone to provide assistance that is beyond just, here's the stack of forms, please go figure out what it is you need to do next.
I think one example would be
And I see you, Bridget, you're next.
healthcare. That was an area where I'm not actually even sure what that means. I don't practice that. I actually don't know anybody that practices the people law form of healthcare that was represented in the Access to Justice survey. I imagine it's like helping with bills and that sort of thing, but I don't quite know. So that might be something where maybe there isn't a limitation. It might be a currently completely unmet area that people need some advice and attorneys aren't, giving them help. But I think that in other practice areas, it would be approached very differently. Personal injury is probably not going to be a practice area that the paralegals would be going into, or maybe that would have a very, very different line drawn. And so I think it's going to vary, but in some instances, I think it'll be pretty broad, and in other instances, it might be very narrow.
Bridget?
I agree with Andrew that I like the overall approach. I think it makes a lot of sense to build off what you already have with the paralegal and how that's already. What makes this scary to me, and what I think based on the comments we have heard about this, is that this appears to be basically unregulated. So we're going to, I don't think posting a bond is enough to, in my viewpoint, from a consumer protection standpoint. I recognize my colleagues are gonna probably have different opinions on this, but to me, I'm not opposed to opening this up, especially as we talked about, there's a whole gap where people are not getting the service at all. But to me, I think a licensing scheme makes sense in this environment. So I think that's a lot of what we heard in the public comments is that people, not to get back into this whole Notario thing, but I do think that is part of this discussion, is people are out there representing other people and there's no system of accountability or oversight without a licensing scheme. And so to me, I think all of this makes sense, but I would propose that we would recommend a separate licensing program.
Okay. Lori?
I think I'm just going to approach this from whether I think this has any impact on access to justice, and I'll share that as a paralegal or former paralegal. I think the idea that even though there are 27,000 paralegals in California, expecting paralegals under this model to then create a workable business model that is going to impact enough to make a difference, I actually don't think it's workable. If all you're doing is taking paralegals and saying, build a similar business model as lawyers have, but do it cheaper with less resources and education, I am not seeing where there's going to be any real impact. I think what we've heard from this task force is, number one, anyone who goes down this road just because they're a paralegal, so we empower paralegals who are already certified as paralegals in California, the idea that they're not going to face a lot of threat and pushback from lawyers in those same areas. This task force has had several months of constant and regular questioning of intentions and why we're here and what we're doing. Those paralegals are going to face the same kind of level if they then try to build a workable business model that mirrors so closely to what lawyers are doing. So ironically, I am actually not in favor, I think, at all of taking away a tiered approach and a licensing. I think we need a licensing. I think if the bar is looking to increase access to justice and build new business models, simply saying, hey, paralegals, go do what lawyers are doing, but do it cheaper, they're not going to have the resources, the education, or the ability to deal with all the threats that I think come their way. And I think what we do is just create a Band-Aid approach that does nothing. Because if lawyers aren't building these things for things like family law, I don't think paralegals are better equipped to do it. They're going to make less money doing it for a cheaper amount with the same amount or less resources than most lawyers have to do that.
So okay. We've spent a lot of time on this particular topic, and there is a lot to accomplish today. And I feel like this is we're starting to go back down the conversation that we've already had. I think we're closer to a consensus than we have been before. And I'm willing to go back with Tara and for us to incorporate maybe some additional stuff around, some clarity on practice areas, and maybe some more concrete suggestions for ADLs too on how to think about practice areas, because I'm very opinionated. I know Tara is as well, which actually is awesome. A licensing scheme, I think maybe a little bit, I'd like to talk to you kind of independently, and then let's maybe incorporate some of this specific stuff. I'll come to you, but I really want to be able to move past sort of an open, broad discussion, try to get us to the next topic if possible. I'm very keenly aware that we've got a lot to accomplish today. So with the permission, with Tara's first.
I just want to add that, our proposal did contemplate a licensing scheme, that there would be, again, these practice areas that were set up and that they have to meet the certain criteria and apply to whomever and be able to practice that limited area of practice that they qualified for. So it did contemplate that, and maybe that's not clear in here. Again, Joyce and I were both sick over the holidays, and so
There is no time for that.
There is not, there really is not. Well, I'm still 2 weeks behind on life. So, you know, I think that's still contemplated. Also, this is not exclusive of our other ideas, which would be like the tech ideas. So, you know, I'd like to hear more about, I guess from Lori, whether it's now or later, that this is not like our one solution. This is our proposal in lieu of the triple LT approach, or just kind of a way of achieving the triple LT approach without calling it triple LT, and by using an existing existing words, existing educational programs, existing infrastructure, and not starting from scratch. So, I mean, I don't know whether we could move for a vote at this point. I know I'm personally very limited on time to help Joyce, but you know, that's kind of where we're coming from, and so I agree with your comments that it's not going to fix anything and that it does need to be regulated, and it does need to be limited. Those are all correct. I believe that all was our intention here.
So, Toby, and then Kevin.
Okay. I clearly agree that the regulatory scheme is necessary, and it's not in here. It needs to be, maybe you don't need to discuss what it is, but there needs to be something in here that says, subject to a regulatory body that will oversee this process. And I think that's what gives consumers the confidence, is that there's somebody looking at what's going on. Because we have all these other groups now that are doing similar things that are authorized to, that have no oversight at all, although in theory they do. I also think when it comes to mention, just putting the words in there may represent in court, even with a question mark. But that's such a big red flag that the whole thing goes away. But I think if you put in the navigator can assist in court rather than represent, because representation in court, you know, we talk about evictions as being an obvious, well, do you really want a paralegal handling a jury trial in an eviction case or any other kind of case? So I think assisting court, you know, a la the navigator might be an appropriate way to take at least some of the red flag away.
Maybe assist a client navigate court?
Yeah.
Or serve as a navigator in court.
Yeah, in court. Just two other really quick things. One of them, we had talked about this and then it didn't appear, but we talked about the educational requirements for the paralegal. What about somebody who's gone to law school?
Right.
But that meets the requirements. So when you consider all of the types of people that we talked about wanting to have access, someone who's been to law school would meet the requirements of a paralegal. Someone who
Only if they have the 1 year of law-related experience.
well, there's a number of different ways you can get it, but my point is that it would include those types of people. Yeah, so they need a year of experience. Like that's big deal. You go work for a firm for a year and then you have it to be independent.
All right. And the other one is that there needs to be, I think, and maybe this is too granular, a reference to Rule 5.3.1 that says that lawyers who've been disbarred or suspended can't qualify.
Fair enough. Tara?
Well, I mean, not to play devil's advocate here, but under a regulatory scheme, I think that person would maybe have the ability to apply. I don't know how it works under the state bar, but attorneys who are disbarred for, say, alcohol abuse, have a way to come back and redeem themselves. So I would only suggest that, people that are in hard times and things happen in their lives, that there at least is a process that is the same as it is for an attorney to, apply.
Okay. Kevin, I think you were, Mark, I'm sorry, I apologize.
I have two questions. The first one is you have a brief statement at the very end about why the tier approach is too complicated. I'd like to know more about that. I think what we talked about in the past is there are certain levels of legal advice that might require a different type of qualifications than others.
So there were two components of the tiered approach that we found challenging. One was the attempt to incorporate technology into the UPL exception that we were writing. And so we found that muddied both both pieces. It was hard for us to kind of envision one set of rules that would apply in both cases, and because the technology stuff was more related to the sandbox and the fee sharing and the non-lawyer ownership, we just took that piece out. So that was one aspect. And I think the other thing was trying to come up with language that would help the consumer understand what distinguished. That's why we liked the independent paralegal. It was, a way to sort of distinguish between what a lawyer does and what a another category might do. Having too many categories just to us seemed, from a marketing and consumer education perspective, to be more challenging.
Yeah, I can understand the technology aspect of that, but there's a lot of individuals with or without technology that can do a certain form of legal advice and doesn't create the complexities that others form of services can require. So to have a one-size-fits-all in a regulatory scheme like this may be more complicated than necessary, is my observation. Secondly, trying to pattern this after the State Bar Act 6450 is a whole statutory scheme, and is it your intention that this become a statutory regulation? Are we going back to the legislature to accomplish what you're trying to accomplish?
Tara, this is a lawyer question. So the 6450 is
well, I mean, paralegals is a defined term in the State Bar Act, and all these regulations that you've set out here are part of the State Bar Act. It's not in the purview of the State Bar or the Supreme Court. It's that the Supreme Court have oversight, of course, but you'd be going back to the legislature to amend this statute, I suppose, to create an independent paralegal framework, and that will have its own consequences and complexities. I'm not sure we need to do that. I think there's things we can do in the legal profession that will enhance the provision of legal services, but I'm just asking, the question is what you envision this to be.
Yeah, so I envision this as, again, the way we approach the triple LT. We've been told repeatedly that the higher powers are interested in a triple LT proposal. And so I don't know that I want a triple LT proposal. I think there's other things we can do. But this isn't my personal belief, but I think that if we're going to approach it in the triple LT manner-esque, this seemed like a good way to do that, and that it avoided some of the pitfalls that we've seen in the other areas. So I would like to see, multiple recommendations that also, approach our goals in different ways, 100%. But I think this is just one way.
Okay.
I just want to address Toby's comment about the red flag. The use of the term representing a client, again, I think that would be a red flag. There are legitimate reasons to worry about that, and then there are also legitimate fears that those words might trigger. And while I think we should never cower to the illegitimate fears of the bar, the attorneys themselves, there's a way of avoiding that. I think it's very clear. A navigator, at least in theory, would communicate just to the just to the party, and then the party talks to the court. Whereas a representing attorney does the opposite. So it's a very clear bifurcation for people.
Although in some states, the navigators are allowed to answer questions from the judge.
Yes.
So they can communicate, but they can't initiate communication.
Exactly. Yeah.
Lori.
Sorry. Sarah, can I ask a follow-up question? So I know that there was a lot of discussion last month that I missed, but I think that going from the tiered approach to the IP, independent paralegal approach, was something that you guys worked on kind of afterwards. Is that right? I think I'm trying to understand what narrowing who can provide these services, what problems you think that avoids from the triple LT program, because my understanding is some of the problems with the triple LT program are there are not enough people engaged in it to make an impact.
Can I respond to that too?
Yeah, so I'd love to hear, I understand this is complicated and this makes it easier for us to present, but I'm trying to understand what problems it will solve with.
Okay, when Jillian Hatfield was here, she reported to us that the LLT program took 15 years to implement. And it took 15 years to implement because everybody argued about exactly, what the educational requirements were gonna be, how, what they were gonna be allowed to do. And it was a very long and arduous process. And so we wanted to kind of take a stab at actually defining some of that and kind of bypass some of those conversations, simply because we don't want to make any kind of a recommendation. I don't think anybody on this body wants to make a recommendation that will not see any sort of implementation for 15 years. So that's the big one, is like that's why we're so focused on trying to build something off of an existing infrastructure rather than creating something from scratch, because all of the other requirements seem to take a very long time to do. So
do we think there are enough paralegals who would have an interest in this to make it,
I have absolutely no idea, Lori. Really, honestly, I think we've seen a couple of broad topics repeatedly brought up again and again, ADLs, and one is sort of the technology solution, expanding the one-to-one ratio to allow for sort of more direct assistance, and how do we do that, as well as some just regulatory reform. And so this is just our response to kind of that broad category. I think there's plenty for the ADLs 2 folks to do to figure out if that is the right way to go, and there's still the Board of Trustees to tell us whether or not they think it's a good idea. It's just something that we can, as Tara has said, we just keep kind of coming back to and trying to find a way. I think there's lots of granular stuff to be still figured out, but I think that's why we tried to do as much as we did in terms of saying, okay, we're not gonna do 10, we're gonna just do 1. We're gonna see if we can get 1 all the way through the process as a way to start, as a way to open the door. This doesn't have to be the last time that we.
I do have one addition, is that when we were thinking of the tiers, we really realized that bottom tier was really information-based, that we, and so that's why this is kind of the second tier. We still want the first tier to be more open, but like I think maybe you were getting at, is that that's not going to happen with one-on-one. That's going to be tech and getting information out there better, and I think that's going to come hopefully from some of our other rules, like the advertising rule, maybe the solicitation, those types of rules, as opposed to who can offer it. So even though this might be more narrow than kind of the tier 1, I'm still hoping that our other proposals will continue to expand tier 1, and this is just kind of opening up that middle tier of the one-on-one, but not to the exclusion of the other stuff.
Just for clarification, would the idea be that the independent paralegal would be limited to a specific practice area, practice of law? So they'd be a independent paralegal in this.
Yeah, and those would be informed by the gap study.
Perfect, and that was gonna be my second one. Would the gap study basically say, and we're looking in these 5 or these 8 categories? We're not looking at somebody coming in for patent.
No, and the only reason that it's probably not as well articulated and that's my fault, is because I keep coming back to the name change tool and how very successful that was, addressed to a community that lawyers don't provide service to, legal services don't provide, free civil legal aid isn't a part of it. Like there's nobody, as nobody doing it. And so there's this tension, and Tara and I, have had a lot of conversations, and clearly have not landed on the right language that would say, we certainly want to kind of constrain this through the practice areas identified by the State Bar's gap study, as areas of need where clearly lawyers are not currently doing anything. However, I am loath, I use that word deliberately, I am loath to only limit it to those and not perhaps open it up to places like name changes and gender marker changes for the transgender community, which don't show up anywhere because nobody's really looking at that.
Yeah.
And so I don't know how to do that. I will say that, perhaps we constrain it by the gap study with the idea that other opportunities, maybe that's, people could apply for specific areas, and if they can demonstrate a certain vulnerability, population that exists that nobody is currently serving, maybe there can be a waiver. I don't know the language, but that's why it's kind of muddy. I'll own that.
I fully agree with that.
Yeah, and then thank you for that, and I appreciate that. The other two is that I'm seeing pop up right now through the law schools is this new Masters of Legal Studies. So it just seems that the law schools are putting out these non-law school pathways right now. So Pepperdine has a program like that. We're just saying, and the conversation is it's basically law school for non-lawyers. So I think that there's probably also a way to tap into that community, that you're looking at people being educated in legal, but not to be lawyers.
Andrew, you had something to say?
Yeah, I would just say not to ignore the master's program, but also just undergraduate 4-year degree programs as well. Some schools are offering some great ones.
If I could add something about the master's program, Western State has one, and it's in compliance. So it's really for non-lawyers who want to get a leg up in the business they're working for. I'm not sure it's a people law type thing that it's addressed to.
Some law schools have also adopted something that's being called an executive JD program, which also doesn't qualify you to sit for the bar exam, but you're essentially taking the same course load as law students.
Okay, this has been very helpful. What I've heard is that there have been a lot of suggestions about ways that this might be tweaked to make it clear that there would be some regulation of this group, to focus on maybe perhaps really highlight that it's prohibited practice areas and maybe identifying what some of those are. And so there have been lots of good suggestions. I guess the question that I have for this group is, I think it would be helpful just to take a straw poll, literally with a show of hands, if how many people think it's worth going forward with revising this proposal, bringing it back on the February 4th meeting, but it's worth pursuing, as opposed to those who say, I'm implicitly opposed to this, I hate this, yes.
Just one qualification, because I know I don't have a vote, but I would abstain if I didn't know the answer to Mark's question. If it was a court-driven exception to UPL or statutory exception to UPL. And I think the best way to duck it is to simply say that this task force wouldn't say implemented through X. We would say the implementation body should consider the appropriate parameters for implementing this. We're making sort of a riff off the statutory regulation of paralegals. We're not trying to have anybody infer from that it has to be 6150.1. It's going to be implemented, how it's going to be implemented. And the most recent thing that happened is military spouses, which was a rule of court. So I think we can avoid some abstains or no's if we say we're not saying it's going to be statutory or rule of court. It's open for the further consideration.
So, okay, wow, okay, so Mark and then Simon, and did somebody else over here have a hand? Okay, go ahead.
I'm going to build on that, because I think to vote in favor of this proposal, it'd be great if we could just kind of coalesce a number of these concepts. I know the name's important to you, but there are other names too, like paraprofessional and things like that don't confuse paralegals with non-paralegals. But putting that aside for a moment, what I'm envisioning is you could end up with either law school or other courses and instructions to enable people to perform certain tasks that lawyers now perform that would otherwise constitute the practice of law. And that can be regulated. I would prefer it not to be by the legislature. It's just very complicated.
I agree.
And you're going to be delayed for a while. We've already delayed ourselves for a while, just getting to where we are now. It's going to be even worse. But I think there is a consensus here that you could have a structure where somebody who's not a lawyer could be schooled or trained or get a certificate or go to courses. This master's program, although it's not fitted for people, can be restructured to train someone to be qualified to perform certain levels of legal services for consumers in specific areas, and have a licensing and have a regulatory scheme. I don't think anyone in the room, I doubt anyone in the room would disagree with that. But we're struggling with how to say it, and I think I would abstain, I'm sorry to say, with this vote, the way you're going to cast it. But it's not because I don't want to see it happen. I want to see it happen. So.
Am I understanding you to say that you don't think it ought to be tied to the paralegal concept?
Yeah, I have concerns, but I wouldn't let that make the ultimate decision for me. I mean, if that was the only concern, I'd probably let it go. But the paralegals has a long history to it, and it's a regulatory scheme under the State Bar Act, and there's a lot of confusion. If you have a paralegal and an independent paralegal, you're going to have some consumer confusion there. I'm not hung up on that. I'm more hung up on the fact that I think we're in agreement that there can be a level of service that a non-lawyer should be allowed to perform under some regulatory scheme. And we're hung up on a lot of the nomenclature. And I'd like to see this little subcommittee go back and kind of think or structure that. And then you'll get a lot of support, I think, among the members of this committee. That's my 2 cents.
So I would just want to first say thank you to Tara and Joyce for putting your time into this. I couldn't agree more with Randy. I don't think I've ever said that.
You'll learn to like it.
Yeah. Randy said it perfectly. I think the intent is there. I love this idea, especially with new education opportunities, masters. I think this is really encouraging and awesome. I have similar concerns about the education and that, and I agree just generally we should leave it to the implementation committee. I will also abstain, but I wish there, and maybe you two would be open to some friendly amendment that just says we encourage this kind and leave it to the implementation. Sure.
Friendly amendment?
Yeah.
I mean, it doesn't have to be called that, right?
Right.
I'd like to see us pass something, because it sounds like we're all on the same page. We're just hung up on words, and any two people could come back with 2 words.
Yes.
I think that the paralegal, whether you call it independent paralegal or not, maybe just starting with that erasing the title, but starting with those concepts, that there are these 4 or 5 different ways, maybe 6 different ways that you can get education in a specific area. Maybe paralegal is one of them. Maybe that's our starting point again, because we already know that 27,000 people meet that criteria. We don't have to start from scratch. Is that something that you'd vote on? And then I would suggest, I am in trial prep, so I cannot really help you further, Joyce.
Sorry.
But maybe Mark can, or Toby. I think we need one of those people that thinks about these things in a little bit different way than you or I do to supplement you, and you already know how I think. So you would represent me in that. But I don't know. I'm wondering if we could pass something and then you can refine it.
Wasn't the vote though going to be just whether we think we should refine the memo and then have something else to vote on? Because it sounds like you both agree that this is a concept worth continuing to pursue, which that was my understanding would be what we would vote on. That's all. I just wanted to clarify that.
It was, but I think what sort of fundamentally what these folks have indicated is that it ought to be broader than just this paralegal concept it currently is. And I think that we're all open to that. I think that's a good idea, and we've heard it a lot from that end of the table, and I appreciate that. It's really important and a good idea.
And is there another? Oh, sorry.
I just want to point out, because I know that we've all spent a lot of time talking about words and then meeting on this task force over the last year. I do think that the reason why I feel like this is so important that we're careful with the wording of this is because the amount of time we're spending on coming up with this vote and this memo, people take this from here on and do specific action based on those words. And so the more narrow this is, the less likely I believe that it has any impact. So for me, I am always for broadening who can help people in the space. And I think that if we can just get away from the idea of an independent paralegal and really open it back up to that more tiered thinking, I think that we want the implementation crew to come up with, I think when we start small, the implementation crew takes it smaller. So what I don't want to do is waste a bunch of task force time on words and proposals and things, and at the end of it, the net ends is, so I think those words matter more than we're maybe, so.
Yeah, and then Joanne. Just real quick, couldn't we just get rid of, I think people are getting hung up on the paralegal and paralegal part. Can we just say this recommendation seeks to create an additional category of a type of paraprofessional who would be to be determined by the implementation committee to get it, so we don't have to sit there and haggle over it, who would be authorized to provide blah, 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 if everyone else is okay with the rest of it.
Joanne?
The governor just announced his budget this morning, and in the budget is the court navigator program that the Chief Justice has been backing. I think when we come back with some more documentation that we talk to the court to find out what they had in mind, so we make sure it's broad enough to encompass what's covered by the new budget.
Why, thank you for that late breaking news.
That's what I'm trying to find. It's not up yet, so.
I was just asking Neil if he had a description of exactly what it is, but.
It'll probably come out later today.
But we will do that before.
Yes, thank you. I found it.
Oh, you did?
It's 8.1 million.
Right.
For 2020 and 15.5 thereafter annually to on-court navigators at trial courts to assist unrepresented individuals with navigating the complexities of the court system. Court navigators will help bridge access to justice gaps, improve customer service to court users, such as collaborative court participants and victims and family petitioners, and increase the positive impacts of existing self-help services. That's all it says.
Certainly incorporate that into the language.
Although I think you may find that the educational requirements for the requirements for these folks may be less than what you would contemplate for a
Right.
not wanting to call it triple LT, but triple.
And are the requirements already set forth?
No. This is the entire language I found.
Okay, so there may not be, do we know whether they've created it yet?
Well, you were saying it's.
There would have to be some kind of work that figures out what the requirements are, what the education requirements would be for this new group. So it's very, very, very early. But obviously this is something that falls into this issue.
Am I right that this is contemplating court employee navigators
Oh, that's
I
interesting.
think so.
rather than
Yes.
freestanding independent?
Yes,
So
yeah.
they are supervised by
The money's going to JCC, yeah.
Yes.
Oh.
It's a different animal.
Randy, how much of a vote do we really need today? I mean, I hear a consensus around the table. This is something worth going forward with all of the tweaks that we've talked about to improve it, broaden it. Do we need?
I think it's less of a vote and more that the persons who are gonna advance it to the next stage have enough information to really set it up so that we can vote on it the next time, because that is really that's the last gap, the next meeting, so.
So as Tara's already, which I totally understand, you're, getting ready to go to trial. So I will take what I heard, or maybe the staff will help me with the regulatory stuff that you were, the 64.5 language,
Well,
whatever.
Mark, are you willing to sort of?
I am not going to be at the February 4th meeting, I'm sorry to say, so I'm probably not a good candidate. I'm happy to look at it before the meeting, but I will not be here.
Okay, looking at it for the meeting is the.
And would you would do, okay, I'm gonna give it a shot and pass it around. I'll come up with a date here, let me look at my calendar and, in anticipation of having something. Yes, go ahead, Randy, you were.
Professor Moore, would you be willing to take a look too?
Sure.
Okay.
So I've got Mark and Kevin and Toby, and does anybody else? I don't care, I'm pretty open. Okay, Bridget? Okay.
The only other thing I would ask is, Kevin, you had a number of comments along the way in this thing. Is there anything that you felt strongly enough about discussing or felt strongly enough about that you want to discuss today and you think ought to be built into this?
Not really. I mentioned it's already been addressed in our discussion today about the court appearances, and what is the extent of the court appearance as opposed, navigator, which is what it sounds like people would prefer that be limited to under these circumstances. And I did raise the other issue about privilege, and that comes up also in the discussion with respect to the technology companies. There's two different concepts, confidentiality and privilege. Confidentiality is an affirmative duty not to reveal information, not to disclose information. But the privilege is there, it's an evidentiary privilege to resist a compulsion that's brought by a subpoena to get at the information that a client may have communicated to the lawyer or paraprofessional, or the advice that a paraprofessional or lawyer has given to the client. And it's very important in our judicial system that there be a privilege. And that really hasn't been addressed in this proposal. And I guess raised that issue. And I just mentioned that as a reminder that it should be addressed to some extent.
Mark.
Because if what you're looking at, if you want to get people to be comfortable to come to you, and then you tell them, well, I won't reveal the information, but if somebody calls me into court, I can be compelled to reveal it. Then, or they really want to talk about their problems with the legal service provider.
Since we're trying to talk about concepts here, there's a couple of important ones. I heard a comment made earlier this morning that this proposal would not be to the exclusion of what I would still consider to be the tier approach in the use of technology, for example. So I think that ought to be made clear somewhere that we would not want to foreclose the opportunity to recommend licensing the delivery of legal services through technology by qualified providers that don't necessarily meet these qualifications. And let me give you an example. One of your proposals here is that there be some type of background check, for example. And I know others have talked about maybe they need a moral character a review or something like that. Well, that would probably not be necessary in certain entry-level services through technology, for example. You wouldn't, the fitness to practice requirements would not be as important as it would be for someone who's actually in a confidential relationship and giving advice and perhaps possible representation. So as we write this, if you could at least make it clear that this is sort of tier 2, I think it was mentioned, that this is sort of a higher level of the types of other delivery systems that we're hoping to also recommend. That would be helpful to me, that we're not superseding that type of entry-level system. Secondly, to pick up on Kevin's point, you're going to run into problems, I think, when you try to characterize this relationship as an attorney relationship. I don't think you can do that. And the reason why is that the attorney-client privilege, for example, which is a statutory privilege in the Evidence Code, but which has a whole body of law as to what the elements are, it wouldn't fit this type of relationship unless you want to change that definition. Better to say, like we have in the Evidence Code, that there can be a privilege, like there is one for lawyer referral services, for example. So you could recommend that the communication is not confidential, but that it is subject to not being discoverable under a privilege. But the privilege would not be the attorney-client privilege, because if you do that, you're opening up a real quandary of just unnecessarily complex issues. And you shouldn't do that. So I would not create an attorney-client relationship with this independent paralegal. I would create a confidential relationship with a lot of bells and whistles. We have to decide how many fiduciary duties does that person have. We don't have to deal with that here. But be careful with that type of discussion. And yes, there ought to be a privilege, but it should be something in the Evidence Code that is distinct from the attorney-client privilege.
Okay.
And just following quickly on that, keep in mind that federal attorney-client privilege is different than state. So if the state says we create an attorney-client privilege, that doesn't bind federal courts.
That's right.
And they can.
You guys need to stop talking like I understand any
So
of this.
if it's a bankruptcy case, if it's a bankruptcy matter or immigration or some other federal law matter, even creating a privilege in California might not be enough.
That's true.
So we're very glad that you all are looking at this after you get the draft.
From Joyce.
Joyce and Tara, thank you so much for all your work on this. We really appreciate it. Okay, I think at this point, unless somebody has anything burning that you want to add on this, well, even if you do, over lunch, you can grab Joyce and tell her privately, but I think maybe it's the point that we ought to move on. And so the second piece of this UPL exception has been the tech side. And we have all acknowledged that it's really a different issue when it comes to the tech side. So I guess our tech experts, we've got Dan and Mark and Kevin, I think, and do you hear the emphasis on Dan? Have worked on this, and so why don't I turn it over to you to just for a few minutes talk about this piece.
Well, let me just thank Mark and Kevin first for legal-defying this. It sounds a lot better. That's great. Just scrolling. Okay, here we go. So the changes to this, I mean, there are small wording changes here and there, but the broad strokes are fairly similar to what I talked about last time. Again, at a high level, it's that legal service technology providers, LSTPs, we're not tied to that, but that's what we'll call it for now. LSTPs would need to meet certain accessibility standards, and we would be very clear about what those are, and those would be able to change over time. But they would also need to go beyond those sort of very formal and defined accessibility standards to also provide user experience that is this is a little harder to define, but things that are more accessible as far as I guess the flows and the touchier, feelier kind of elements of good application design. There are standards in user experience more broadly, but they're kind of always changing. It's a fairly new field, so I don't know that we're pinned down to anything yet. I don't know that there's a widely accepted standard, but I could be wrong. So if any of the public on the phone or anyone that ends up hearing this later on wants to correct me on that, I'd be more than happy to hear it. And then third, the prohibition against dark patterns. This follows the language from a federal law, or a federal, it hasn't been passed, but it's been proposed by Ron Wyden of Oregon in the Senate. And hopefully that will get through, although I don't have much confidence in that in this environment. But it talks about how dark patterns are the design choices that subvert or impair your autonomy as a user. So we don't want to allow technology providers to start bringing in all these really deceptive technology practices. And to be fair, I think we should probably consider that for lawyers as well. But that's not the point of this task force. So then I think fourth, there is a recognition that we need to have similar duties and remedies as lawyers, as far as things like limitation of liability clauses. As I mentioned at the last meeting, there was a really sort of embarrassing episode where someone pointed out a limitation of liability clause in my company's website. Things like that shouldn't exist if we're getting legal services provided through technology. That's going to up the insurance costs, so be it. There should be an insurance level set by the regulator for errors and omissions and general liability. And let's see what else. There should be a privilege similar to California mediation, confidentiality that that protects information from subpoena or discovery. And then finally, there should be careful implementation of algorithmic systems. And both the regulator and the technology provider should look very carefully at what they're implementing. I don't know that there's anything actionable from that. I think it's just sort of a note that everyone needs to be careful. And then finally, the regulatory authority, the regulator needs to be granted the authority and budget, importantly, to actually enforce these rules.
Okay, thank you very much. Mark and Kevin, do you have anything you want to add?
No, except that on item 4, that's where I focused most of my attention. And I really want to get clarification from Randy and others. I sort of see our role here is setting up sort of a issue, sort of a policy level discussion. There's a lot in this paragraph that you can discuss. It's just an awful lot of detail here that hasn't been implemented. But I don't see our role as providing specific recommendations on how to achieve some of these standards. But just from a policy level, these things should be considered and dealt with. Just for an example, we say, for example, that as with lawyers, the LSTPs should advise consumers whether or not they have liability insurance. Well, if I were writing the implementation of this, I might be in favor of requiring liability insurance. Liability insurance may or may not be the same as malpractice insurance. There may be different, there's all kinds of different kinds of insurances. So I'm just saying as an example, we're not delivering a paper that gets into that, and it shouldn't be read that way. So it's really kind of 30,000-foot view, I think. And unless Dan disagrees, it's just it's more conceptual.
Kevin, did you have anything on that?
I don't have anything to add other than just to say that I think this memo is trying to set out some general principles about what any LSTP should, general principles under which these LSTP should be regulated.
Okay. Toby.
Yeah, I shared this with a number of disability providers, legal services providers, to get some feedback. And unfortunately, a lot of legal services programs close over the holidays, so they didn't even see it until Monday. And so I didn't get a lot of feedback, but I got some. And maybe it's 1,000-foot rather than 30,000-foot information that I want to put it out just because I got it. Your reference to the standards, the WCAG, what I'm told is that applies to the web access issues, but that it needs to also include any documents posted or accessed through that web access, so that they have to be accessible as well.
So like you can't put out a non-machine readable PDF, for example.
Exactly.
I think that's a good note.
There were a couple of others, but the next one, the other one was, the major one was when you do the use, whether it's under user experience or licensing, whatever, that the testing that you do to make sure it's in compliance with all these things ought to be sure to include testing with persons with the disabilities to assure both practical and functional accessibility.
Yeah, and I think that was sort of the overall thrust of the second section was that the very technical WCAG standards, that's one thing, but that's different than creating a broadly usable application.
Yeah.
Joanne.
This memo seems to fit right into the regulatory sandbox model, just outlining things that we need to make sure that under the sandbox is implemented. So I see those as being read together.
Exactly,
It's just, we
exactly.
want the regulatory sandbox to look at these.
Yep.
If I may, in 2014, the federal government created the U.S. Digital Services Organization Department, essentially. They've got a digital services playbook that's available. It's a 13-page checklist of everything that the departments need to require of anyone that's obligated to follow best practices and that type of thing for those of us that work at the federal level. It's very clear, it's updated constantly, it's literally a checklist, and it's considerably, nothing against this memo in any way, shape, or form, but it's comprehensive. And this is the existing model that gets updated annually for everyone that does federal work. So it's by far a better standard across the board.
It's very good.
Yeah.
So does it make sense to just incorporate a reference to that?
Yeah, I think that totally does, yeah. The USDS checklist is excellent.
Okay, this is terrific. Thank you very much for all the work on this, and I agree, it dovetails beautifully into the sandbox. I think that's a great segue, and so why don't we turn to the issue of the sandbox. Joanna, Bridget, and Andrew, thank you all for your work on this. And so I'll turn it over to whoever wants to take the lead on this to talk generally about the sandbox concept.
Okay, so I know this is a lot of information, but thank you to staff too for putting in these really helpful references about what Utah is doing. I think that was newer than even what we turned into you, so thank you. Basically, the way that I am looking at this, and I hope this is how other people are looking at it, is, and I realize we still have to get to a couple other rules, but I'm kind of seeing us crystallizing what we're doing into kind of two tracks almost, just kind of the way that Utah ended up doing it, which is one is like the individual track, which is what Tara and Grace was doing, and this is the entity non-layer ownership track. And I think the way I'm thinking of it are the other rules are kind of ancillary to what we end up doing with this. But the sandbox idea is a way to take the non-layer ownership fee sharing situation and put it in a more controlled environment, as we talked about last time. And what we've written up here basically takes the Utah model into consideration. We've added some of our own ideas about some additional things that we would like the regulator to impose on applicants. But really the idea is to try to be as open as possible so that people can innovate in what they're trying to do. We would have this model of risk-based regulation. So there are three things that we've identified here as potential harms that can come out of this. And so one of it is that consumers would receive inaccurate information, that they would not exercise legal rights that they should be exercising because of bad advice, or they would be pressured to purchase unnecessary legal services. So those are the three types of harms that we want to protect against. And it's a really different way than we typically regulate, which is like prescribing out what people can do and not do. So it's kind of different for us to think about. But essentially, entities can come up with ideas. They would work with this regulator to apply. The regulator might look at it, and then they would work with them on collecting data and allowing them to go forward in a more controlled environment. And in this way, the existing rule, I think the way this should work is that the existing ethics rules for now would stay in place, but for people that are participating in the sandbox, they would be loosened on a pilot basis for us to see how this is working. And then what we don't have in here, and I think we do need to flesh out a little bit more before the end of the day, is what happens when it's over. So I think it should be, I think what Utah is doing is basically they're anticipating a 2-year time frame for their sandbox, and then assuming it's all working, they're gathering data, and they're basically having 2 phases. So they're gathering data in phase 1 to figure out how phase 2 will go, which is like the permanent version of this and a more broader scale. So, I don't know if that makes sense to everybody, but that's kind of that's the gist. And as far as funding goes, so people would pay application fees to be part of it. And that would fund what is happening, and maybe we could get grants or something like that. And then we've also talked, we put it in here, about ways that we can incentivize participants to develop technology that would specifically address the justice gap, like lower licensing fees, or this idea of an incubator, which makes somebody, additional help to help them develop it, could be given to people that are trying to target the specific population. But the way that we've written it here, we're not limiting it to that. Like if somebody wants to do something for profit and they're gonna go out and do it, and maybe it's not necessarily targeting the population that we wanna target, potentially, as long as they're not gonna be harming anybody, they could still do that under this model, but they would, for example, pay a higher licensing fee to do that. Anything else?
I'd add on to that. We tried to closely follow Utah because we assume what's happening in Utah, the same companies will be more interested in California, but it'll be easier for companies trying to break into this space to have the same general set of rules in the different states that are doing it. So it will encourage more activity in these sandboxes. So that's what we were trying for.
Yeah, there's a piece of the Utah report where they say they hope that this opportunity will be available for people in other states. Andrew?
I think the only thing that might be up for a little bit of additional comment is really the data requirements that we're going to put on folks. I think we might want to shy away from having a really strict data requirement in terms of what fields we're collecting. I think what we want ultimately should be what data are those companies already collecting, and how can we not add an undue burden on them? Just because if it's a smaller outfit trying to do something that is really grassroots, having that can actually be a bit of an expense that could be avoided. And I think one thing that really shines through with this is really the point of being that it's really about the absence of harm that's essential to prove throughout the sandbox experience rather than anything else, because I think the status quo right now is no help, and we can't forget that.
Also, to that point, I did notice, because again, this came out after we wrote this proposal, that the Utah, they talk a little bit more about how they're going to do the data, and they say they're going to negotiate the data collection with each individual sandbox participant. So I think that makes sense. So I think they're recognizing that too, and trying to make it not super burdensome on applicants, but still getting information that they're going to need.
Yeah.
And I think the last part that does need a little discussion here, or maybe we can come back to the group next time, but is who will be this regulator? I don't know if we want to just put out options or if people want to talk about it, but the way I have been thinking about it I really would like to talk to people about what they think, but one option would be, I think within the state bar, a separate task force or committee, or maybe this is a version of the implementation task force would be just this sandbox group. And I don't know if they would be parallel to the Board of Trustees reporting directly to the court, or if they would be just another division, as you have your admissions division, you would have a division that is the sandbox division.
Everything goes up through the board.
Everything goes, well, that's, I
Something
think that's
we've
what we should
clarified
talk.
in the past few years is that everything goes through the board.
Instead of, the reason I say this is just because I know Utah is actually really trying to make it just part of the court and not part of the bar. And I think we have a very different bar structure here than they have there. But it does, I think it at least should be discussion about whether, I just think it should be a discussion where it should go, or should it be like a completely independent committee as part of the court? I don't know I don't know if Neil, you have any insight about what this would be, but I do think it would be helpful for us to flesh out in our final recommendation a little bit more in detail about who the regulator is.
And then stemming from that, who the regulator would be, I think a little bit more about how the jump off of this program will go, because I don't think necessarily it's if you build it, they all will come, because folks might not know about it. So I think they're going to need to do marketing around it, contacting the startup incubators that are in our space, some of which have come to some of our open meetings, but just getting the word out that way. So that will require full-time staff to be doing. So I think that that comes with the question of what will funding look like and what will roles look like. And these are now getting into the finer details, which is a great place to be, but nonetheless will be things that have to be considered. So I don't think we should dwell on the structure, the costs, et cetera, but I think it's in our interest to say, hey, this is going to be done properly. It's, we have to ensure that those factors are kept in mind and there's a plan. Yes.
I also think that it might be worthwhile to incorporate into somewhere in here some language that says, because you've got your data collection and you reference independent evaluators, and I think they're, you might want to say, and we're going to have, and every participant within the sandbox is going to have to report to the regulator. The regulator is also obligated. You might, instead of, certainly we can have a conversation about where that regulator lives, but maybe some of the requirements of the regulator, like that they report to the public, they report to the board of trustees, that there are, that there's just some kind of set the table of expectations around in terms of what that oversight is going to be, because so much of the pushback was, tech companies run amok, I'm going to do all terrible things, to have in there kind of, it almost is just closing the loop. You've started it because you've already said, here's some stuff they're going to have to collect. These are the kinds of things that we want to know. Well, then just a little additional something that says, and this is how the analysis or assessment of that information will be distributed widely to the public or to the board of, whoever. Because I feel like that's just, you haven't kind of said it.
Lori.
I think in thinking about a regulatory group and whether it's, I'm not sure I have a strong opinion on whether it should be with the state bar versus a court versus an independent group. I think that it might be better to instead focus on who you think should be in that group and then who's best to pull those people in. And so for me, I would encourage, I think it would be very useful from a sandbox approach. You need people who can think, crazy, blow it all up, wild, wild west, and people who can rein them in, right? You need that very broad group. And I would also encourage us to think about whether we can actually pull in consumers or some part of a consumer body into this sandbox. I don't think Utah is doing that. I think California's focus on consumers is special, and I think that this state bar's focus on consumers is special. And so I think it might almost be better to approach who should be that task force or advisory board and then decide where it sits best.
I'd go further and actually recommend a consumer advocate beyond that.
Yeah, for sure. That's a great one. I also just noticed in the Utah paperwork here, they have, so theirs is composed of, they have an executive director, like a separate executive director, a senior economist, which I think is an important piece, a senior technologist, and the support staff, and then a volunteer board of advisors. But I love the idea of having the consumer advocate for sure as part of the composition. And I think actually both things are really important, the composition of the task force or whatever you call it, and where it lives.
So, okay.
So, let me see if I understand. I'm at the top of page 3, where the sandbox oversight body would be interested in absolute absence of consumer harm by sandbox participant, but the more important criteria is the relative rate of risk of harm compared to the experience a consumer would have received absent the legal services. So going into this model, there's going to be some innovative delivery of legal services to a segment of consumers who do not get these legal services currently. And that would then motivate the regulator, which I assume would have some authority from the Supreme Court, to authorize this program to go forward. And would be evaluating the risk of harm by removing the protections that our current rules afford consumers to a certain extent, depending upon what's being proposed, in light of the fact that these consumers are getting services that they would not get before, right?
Correct.
So now they do that, and there's all this data that's been collected. And now it comes time to decide what to do next. And what is your view about the provider saying, okay, I've done this service for people who never had legal services before, and it's working well. Now I want to expand that program to those who are getting legal services. What would be your answer?
Well, I would say, those, I wouldn't have a problem, but again, I can't speak on behalf of everyone in terms of the services in the sandbox also being driven and given to folks who are already receiving legal services off the jump.
But how would the balance occur in that situation?
Can I ask you a different question? How would you define this population that they never receive legal services or they're not receiving legal services? I think of myself, I've received legal services in the past, but I often use myself as an example. I make a very good income, but I could not afford a lawyer for a very serious matter, or even matters that maybe aren't that serious, but something I'd like to address. It's just too expensive. So have I ever used a lawyer? Yes. Can I afford to pay something? Yes. Am I willing to pay something? Yes, but not $800 an hour or even $500. So I would hope that somebody like me would not be excluded from accessing new service options that might be available through a sandbox, knowing that I would not be the target market. So how would you define this person who's never had legal services?
I'm looking at the consumer what experience that consumer would have received absent the legal services. So
for that particular matter.
Well, fine, but I can't imagine a regulator is going to be looking at this on a consumer-by-consumer basis. But I'm assuming there are people who, to take your example, aren't getting legal services because they can't afford them. And so we're going to have a model that relaxes the rules, allows for fee sharing, whatever else that we're going to relax, to give that person the opportunity to get this form of legal service. So what about the other consumers that can't afford that legal service?
Well, the hope is that the sandbox will bring a wide array of different options at a full spectrum of different prices available to the market. So, for example, we've heard really great examples from Joyce regarding the name change initiative. That was done on a non-for-profit basis. Now, if that organization was allowed to charge even a nominal fee, say 50 cents to $1, and then pour that additional funding into R&D, into a full-time position, they might be able to actually have further reach. Now, that's one example. Another participant in the sandbox could be providing low-cost divorces, uncontested divorce, whatever. I'm making these examples up, Mark. So I think instead of focusing on this, I think what we really need to focus on is what's the harm that is produced, if any, in any of these interactions in the sandbox, and that's why I think we really need to focus in on that. And I think the harm defined is what would have occurred if that individual or organization had not received any legal help at all. And so that's kind of would be where we focus on. So instead of focusing on that side of the ball, which I think could lead to a bunch of hypotheticals, et cetera, let's focus in on what really matters, is what harm is produced, and what are the complaints, if any, that the participants, in terms of the folks who are purchasing these services, experience. Now, if everyone says it's hunky-dory, from those folks who are paying 50 cents for a service all the way to folks who might be paying hundreds of dollars for these services, that's great. But if they have complaints, et cetera, that's where we need to come down hard, swift, and react quickly to those.
But one last question. Is the harm you're asking this regulatory body to evaluate, is the harm to the consumer? Or is it the harm to the judicial system?
To the consumer, because because at the end of the day, the regulations in place are all about the harm needs to be reduced to the consumer, and we're going to just keep that as our bar.
I just want to add real quick before I go to the next question. If this goes back to this disclosure part of it too that we have in here, that, you know, and to Lori's point that I feel like I keep coming back to earlier, that we talked about probably like a year ago at this point. But, you know, consumers can make that choice for themselves. So for people that you're talking about that can afford legal services, as long as they understand what they're getting, who are we to tell them that they can or can't take advantage of this program? I mean, just because they can afford it and they decide like, I want to use this technology, they're going to hire a lawyer. I mean, that, as long as they understand what they're getting themselves into, I don't see a problem with that.
Dan, and then Johan, did you have something? Yeah.
I did.
So I do think we need to have the regulator consider harms to the system as well. If you have a technology that is, say, encouraging consumers to file, 100 lawsuits each, you're effectively DDoSing, distributed denial of service, attacking the court system. That's kind of a problem. I think we need to make sure that the regulator has the ability to consider harms to the consumer primarily, but also to society more broadly.
I would just crystallize that by saying we want a consumer advocate, a judiciary advocate, a representative officer, and a bar advocate officer.
Johan.
I don't think we have a working model yet of the spectrum of technology here. We're lumping it all into one. Even some of the examples that Andrew produced, if you've got autofill forms that are do-it-yourself, that's not a violation of UPL, and once again, you're not there's no jurisdiction, right? So we have to really narrow this down. This has to be technology that is actively doing the practice of law. And that is gonna be tiny. That's gonna be a tiny amount, please.
Yeah, I would disagree, and the reason why is part of what the sandbox is. I think if we go that route, I think we then have to get into the definition of truly what's the practice of law, et cetera.
I know that's like our charter said.
Yeah, well, yes and no. So what I think is more appropriate would be to allow folks to sign up for the sandbox, and if it's just a form-filling kind of company, they are then being given this express kind of assurance that they will not be run amok of any UPL issue. So for those who might want that additional umbrella, that would be great. Now, for the others who want to come in and are doing something more advanced, perfect. But I think we don't really need to have that conversation if we take this approach.
Oh, we definitely do. We definitely do. Right, so what you're describing is an endorsement, as opposed because the only shelter that this provides is from a violation of UPL. So if somebody's not in violation of UPL, but is providing service.
The rules that like prohibit non-attorney ownership, it will also provide protections for litigants.
I think the Utah materials are very instructive here, the December 2019 update, because it has this full delineation of who would need to register with the sandbox, what's outside of the regulatory regime and what's in. And that could be imported wholesale or modified, but I think it addresses your point. Not everything is inside of the regulatory regime. So I think that we have something sort of very well articulated to work from.
So maybe we can incorporate that into.
And that's what I'm suggesting, because it narrows it down dramatically.
But one question I have is the idea that the California sandbox would be limited to only technology-based services, because the Utah one is not.
I don't think it is.
Sorry, it's not. So that would mean it would cover the full scope, and then and that's why I don't think necessarily we have to struggle too much on that question.
We have Randy and then Tara.
So I was just going to mention the same thing Leah did, that in the materials there is an example of an attempt to draw some lines around things, and there are things that would be outside the sandbox, things that would be inside. And on the question of activities that don't rise to the level of constituting practice of law, maybe they're even law-related or ancillary business services, we have 5.7 that we want to get to. If we don't get a rule, it's quite possible that an innovator, entrepreneur who wants to do something in the law-related services arena could go to a sandbox and say, we're going to develop this. We have some lawyers working with us because we want it to be competent. But since we don't have a 5.7, we need a sandbox to bless it so that we can try it. And if it's proven that it helps and there's no harm, then that could be the stepping stone to getting something permanent.
I was just going to support what Johan was saying, that when we're talking about just filling out forms, that just filling out forms is not the practice of law, but there's another level where you're filling out forms but giving guidance to which forms to fill out and how to fill them out. For example, check this box if there is a will. Now we're talking about legal advice, but we're really just filling out a form that under the current structure that would be not proper. So I was agreeing with you that was not sufficient.
Well, I would say there, obviously, there would be an application process and, folks coming into that, they would be able to say, hey, this is a simple form filling. I don't think you'd be a good fit for the sandboxes. You wouldn't necessarily fit. So there would be obviously an examination of that. And part of the process of keeping it so open would be for us to iterate so that we could see who applies, see what happens, and kind of continue to iterate on definitions rather than defining it heavily now, which would leave potentially folks out. So I think taking this approach keeps it open. It allows for us to iterate through it and see what works and see what doesn't.
What happens to the ones that don't qualify or it's not appropriate for? Because the answer I don't want is that, well, then you can't do business in California.
Well, if it's just a form filling one, per your example, again, this is completely hypothetical, but I would assume the application process would say, hey, actually this wouldn't be running amok of any rules anyway right now. Have at it, Johan, and keep on
That's what I'm
knocking.
trying to suggest is that body of technology, we really need to get the definition that is in Utah. And I think, I actually don't think Utah defined it well enough or finitely enough. This shouldn't be all come and we'll let you know. That, everybody knows I'm not a fan of the sandbox anyway. I'm not putting anything through the sandbox. That's not what I do. But the challenge is that I think we've got some default prohibitive actions for people who bring things into the market. And I think 5.7, which I'm a supporter of, does a very good job of breaking down practice of law from law related from non-legal portions that all can close the gap. So I'm just suggesting, again, I'm back to the tiered approach and suggesting that we need to narrow down what, if anything, goes into the sandbox. An AI that's functioning like a lawyer, absolutely. No two ways about it.
Maybe what we do now is we can move on, and that way we have that conversation around 5.7 coming up. We take that all under advisement and we keep it improving.
Well, and I think that, at least I think I heard you say that you all are going to look at how they defined it in Utah and consider
Absolutely.
incorporating that in our, to the
Absolutely.
extent that you think is
Absolutely.
correct and good.
Yeah.
Alan?
Just one comment in response to what you said. By the way, I'm a fan of what you guys put together, but Andrew, it's been my experience that when you apply to a regulatory agency, they're not in the business of telling you like, oh, no, you wouldn't qualify, right? They may construe that as providing legal advice. So I think like in practice, what I've seen, certainly on the legal plan side, is you go to, you just either kind of launch until somebody tells you, hey, you can't do that, and then you have to meet these qualifications. Or when you go to, like, say, the Department of Insurance and you send them a letter, hey, out of an abundance of caution, we're operating a legal access plan. We don't think it's insurance, but we'd like to get your opinion. And they've usually just responded like, it'll only be a problem when we tell you it's a problem. Go ahead. So.
Okay, that was Mark first and then Kevin.
I just, what I'm hearing is that this sandbox approach is not limited to the delivery of services to areas of critical need. Is that correct?
Yes. Correct.
It's not limited to that?
No.
That's what I thought.
Kevin.
Okay, my concern is following on what I think Alan raised just now. And let me see if I have this right. If you go to, based on Andrew's response to you, okay, if you go to the sandbox regulator and say, I'm doing a form filling thing, they tell me you don't have to, you're not a good fit for the sandbox because we don't think that you're really the practice of law or whatever. Well, you don't have an approval. Then if you look at all these on pages, well, the stuff from Utah, where they say the law firms don't have to get information. If that provider, the form filling entity, wants to hire me, a lawyer, to come work for them and provide backup advice to clients who are a little bit worried, I can't do it because they haven't been approved by the sandbox. They've been told to go away. So there has to be something there that, if you say, well, you can't just say you're not a good fit for the sandbox, because then you're foreclosing their options to bring in lawyers to actually provide services to their clients or customers or whatever you want to refer to them as. So I'm a little bit concerned, and I think that needs to be looked into a little bit more.
Let me see if I understand what you're saying. It's because you as a lawyer can't go join that because of the fee sharing issues?
Yeah, I mean, in other words, whereas if it's approved by the sandbox, I don't have to worry about any fee sharing. That would be all part of this regulatory framework that's being set up.
Oh, well, I was just going to focus on that we brought up this whole sandbox issue in connection with agenda item number 1, which was UPL. But it's also number 2. And Joanne raised that point in response. To the extent that you need that relaxing or suspension of the rules for the purpose of either fee sharing or non-lawyer ownership, you're going to come and you're going to get approval for that as well. So we sort of have morphed this conversation into agenda item 2 because the sandbox is both. And you're absolutely right.
But what I'm trying to get at is the Utah materials in that section that they have where you do not have to report. The lawyer, a traditional law firm, traditional lawyer doesn't have to report. And it's as long as the technical entity has approval from the sandbox regulator, I don't have to report as a lawyer, even if there's a violation. That's how I read these Utah materials.
So the Utah, like the working principle one is if you could not do it under the current rules of professional conduct, then you need to notify the task force. So the counter, if you can do it under the current rule, you don't need to notify the task force. So I think under your example, Professor Moore and Johans, if he has a forms product that is not providing legal advice, he can deliver that product now. It doesn't need to go before the sandbox. It's fine, it can operate. As soon as you want to fee share with Professor Moore, that's not allowed under the rules. So that model would have to go before the sandbox. It's not your form, the form part of your business model, it's the fee sharing part of your business model.
Right.
But I do think I tend to agree that because our rules don't actually define what is the practice of law, it may be tricky for business entities to know, do I need to try to get this approved by the sandbox or not? Is it currently allowed under the rules or not? Or am I skating this line that's not clear because our rules aren't clear? So it may be that ultimately it becomes difficult to avoid modifying the rules, but I think the idea would be you wouldn't do it now, you live with some ambiguity, implement the sandbox and use those lessons learned to then modify your rules.
Based on actual practice.
Yeah.
I guess where I'm confused is if I've read those general principles they have, but then under the section which talks about outside the regulatory regime, and we're talking about A and B, the pages are kind of a little bit, if you count the pages, if you have it in front of you, it would be the page 8, which is actually number 2 by Utah. It says at the top, it says paragraph B, conventional 100% lawyer-owned, managed, and financed law partnerships, professional law corporations, and individual lawyers with an active Utah license. And all these things that are listed is you do not have to notify. Yet it strikes me that a lot of what they're doing is prohibited under the rules of professional conduct. And that's what I simply don't understand from these Utah materials. I find it very confusing because all of these proposals, all these interactions that you are providing legal advice as an employee to a third person, which is a customer of this non-lawyer entity.
But that entity under this scenario is approved by the task force.
Right, but that's what I'm saying. But that was my point right there. So long as the task force has approved, that means that I, as a lawyer, don't have to worry about the rules of professional conduct and the prohibitions and the rules of professional conduct. That's what I'm trying to clarify.
Not all of them.
I mean, as it relates to that client.
As it relates to the work that had been put forward and the proposal put forward to the organization, yes.
Fee sharing and, you know, non-attorney ownership.
But it applies,
You still can't commit fraud though.
but it also applies everywhere else. In other words, I couldn't form a partnership that has non-lawyers with an equity interest unless those non-lawyers have been approved by the task force.
Correct.
Essentially, is
Correct.
what you're
Exactly.
saying.
Yep.
So everything is still in play. But as for this one narrow issue, which is going to be done on a provider by provider basis.
To begin with, in order for us to then iterate and find and start to get kind of rules and regulations as we go, because it's impossible to kind of put that into place without at least getting the things off the go and working through it that way. Correct.
Okay, Randy.
I just wanted to mention that in the section that Professor Moore was identifying, B2, and the Utah group made a point to bold font, task force approved non-lawyer entity. I think they're trying to signal that they have a multifaceted attack on the access crisis, and they're going to have task force approved non-lawyer entities offering legal services. Perhaps separate from their sandbox, and we haven't had that yet, but let's say hypothetically there is some sort of non-lawyer paraprofessional human that is approved, maybe it's a triple LT, the board considers it, then something happens faster than any other reform, then our sandbox might have something very similar to B2 that says if you're a regular law firm and you want to share fees with a triple LT that's licensed by under the new triple LT program, then that's going to be completely okay because they are not a lawyer, but they're approved to deliver legal services, and you should be able to partner and collaborate with them as freely as you do with other people who are licensed to practice law. So I think it's a model for us, but we don't have anything that fits that part of the Utah model yet. But if we do, then I think you could use this saying, this is outside of the sandbox because California has now approved triple LT.
Okay, so at this point, Randy, I'm hearing a general consensus around the room that this is a recommendation we'd like to go forward with. What do you need from this group today in terms of a vote?
I think a concept vote that the topics of technology-driven UPL, other innovative non-lawyer owned or fee-sharing delivery of legal services, and I'll reserve the non-legal services thing until we talk about 5.7, but maybe on just those two, that in concept we would like to recommend that the board consider reforms within the constraints of a sandbox proposal. And if you want to append to it, similar to the parameters of the Utah, or I put out today the Wyoming sandboxes, because they are actual law. And they started, I think, accepting applications 1/1/2020. And there's even a med tech technology sandbox that is very similar, or could be very similar to what we do in the legal tech sandbox. And for those who say, well, maybe this is a policy change that'll go nowhere because it'll never happen in real life, here's an example of it in real life. And I would say the people who take this to the next step should look at the Wyoming stuff, because they have things in there like this does not create a property right, which the entrepreneurs might say, well, that's terrible because I want it to be a property right because I don't want anyone to ever take it away from me. But on the other flip side of the coin, the Wyoming sandbox statutes also say, and there is a path to making it permanent. You can ask to extend it while permanent changes in the law are under consideration, or if permanent changes in the law have happened, but you haven't yet been qualified under those permanent changes law. The Wyoming sandbox says you can extend your sandbox rights until you actually are qualified under the new permanent changes in the law. And so I would encourage, take a look at some of these things that address the practical aspects of the sandbox. One of the other things they talk about is, well, what if I'm an operation that's operating in both California and, say, Utah? And they say, well, we, as whoever is the administrator of the sandbox, can go talk to Utah where we're actually doing business and ask for reciprocal relief from prosecution because we're not prosecuting here. We'd ask them to treat you the same way there. And so if you look at the sandbox statute that's already been enacted there and add that to what we see is in the works in Utah, I think you have something that's pretty well formed that an implementation body can take a lot of guidance from and run with. And so I think the vote today is just where we previously had out for public comment recommendations that contemplated changing the UPL prohibitions in the State Bar Act or changing the aiding and abetting rule of professional conduct. We are now recommending that the board consider similar type reforms, but within the constraints of a sandbox approach. And if there's a vote for that, then we would assign groups to try to write it up for us so we have something concrete to approve to go into the report at the February meeting.
So the takeaway from that, and I'm not disagreeing and I'm not objecting to this at all, is let's table it, not say no to it, table it, go hit 5.7 and come back. 5.7 gives us what we need to land this plane.
To what?
To land the plane, to bring it to a conclusion. Sorry.
Don't we have to get it on the air?
Well, we're floating around already.
I think the answer to that is, right now we're going to talk about the sandbox approach. I consider 5.7 to be completely separate. That is, we'll talk about 5.7. We'll see if we pass 5.7 as a wholesale or not.
Right.
If we don't, if we decide not to do the wholesale rule approach, we can go back to add to the sandbox the concept that you could come with a proposal that is law-related or non-legal services and get approval under the sandbox. You don't need to do that if we pass a 5.7, but for right now, we're talking about a sandbox approach that deals with UPL, fee sharing, non-lawyer ownership.
Right. I'm good.
Okay. So you actually want to vote
I think
on the legal concept, on the legal concept?
the fact that that is now the new direction of the task force as a policy reform for the board to consider. So at the next agenda, we won't be looking at things that are related to a rule-based reform. We're looking at all refining and crystallizing the sandbox proposal.
Okay, and we're carving out 5.7. Okay, okay. All right, so Mimi, you want, there's not been a motion.
Anybody have a motion?
Well, I
Please.
I just didn't know because I was part of the group. Yes, motion.
Okay, move, in principle.
That sounds so official.
Yes, exactly. Good luck Mimi taking down exactly what happened there.
Well, the things are going with what Randy said, which was the motion is to recommend to the board that they consider reforms within the constraints of a sandbox law. Does that sound right?
Regarding the topics of exceptions to the existing prohibitions on unauthorized practice of law and other laws governing sharing and non-lawyer ownership.
Okay, you write that out.
We'll do it together.
All right, everyone clear? All right.
Wait, we've got a motion in a second. Okay, good.
Andrew Rita.
I can bring a motion and vote? Yes.
Simon Bodie.
Yes.
Tara Bird.
Yes.
Judge Wendy Chang. Abhijit Chakhan. Jean Clausen. Johan Droshagen.
Yes.
Margie Estrada. Lori Gonzalez.
Yes.
Bridget Graham.
Yes.
Andrew Kuchera.
Yes.
Joanna Mendoza.
Yes.
Kevin Moore.
Abstain.
Heather Morris.
Yes.
Joyce Raby.
Yes.
Toby Rothschild.
Yes.
Alan Rodriguez.
Yes.
Dan Rubens.
Yes.
Mark Tuft.
Abstain.
Angelina Valverde and Joshua Walker.
Yes, and I'm going to add a signing statement to Randy's comment. The sandbox should emphasize in due part the ability to invest in legal practice.
Then I think we'd have to vote on it again.
I'm sorry.
I'll give you a yes.
I couldn't hear.
Yeah, so I'm giving it a yes, but it's conditional, I guess, on what goes into the final, but it's a yes. I'll add commentary.
Obviously, all it's in concept now, and we'll get something back in writing, and you'll have an opportunity to vote again. Okay, it is 12:15, we've got 15 more minutes. Should we turn to under recommendation number 2, agenda item number 2, we've got Rule 5.4, Kevin and Randy.
Tom, we're on B2 now.
Kevin, you want to take the lead on this?
Sure.
I mean, I can jump in real quick.
Sure.
Based on what we just did,
Right.
What we're doing here is sort of a cleanup exercise, because it sounds like the consensus of the body is to more fully explore fee sharing in a sandbox approach, which means not necessarily that you have mooted the discussion of a rule, but we did put out illustration drafts of 5.4, and we did include some very explicit types of exceptions, and one of which was in regards to paragraph A5 of 5.4 that extended to relaxing the limitation on fee sharing with a legal services organization that hired, retained the lawyer to provide the services. The current law says that fee sharing can only proceed if it's a court-awarded fee. And the public comment, if you go back to your November materials where we have all that stuff on public comment, there really wasn't any objection to that part of the 5.4 rule amendment. In fact, there was positive things that would help. And if there's no objection to it and it would help, then I'm not sure if we should reserve that for testing in a sandbox to be made permanent at a later date. And so there is that that we should discuss. And if I can speak to just the other parts of this red line that you see in the agenda materials, that was Randy and Kevin trying to, for legacy's sake, have on record a last, final, best approach to a rule fee sharing reform, which if it isn't voted out, maybe someday someone might want to go back and look at. Maybe after the sandbox testing is over, someone will say, let's start with a permanent solution, and let's start with that rule that they considered but didn't vote out. It doesn't need this or that restriction anymore, but if we change along these lines, we now have a permanent solution to the fee sharing obstacle to innovation and enhancing legal services through technology. So the few things that are different from what you saw the last time is that we've added the Professor Giller's provisions regarding the fee sharers who would participate. And Professor Giller's, in the written support to his oral testimony that he gave in this room last year, was that you will have some probably very well-meaning, good-intentioned entrepreneurs and investors who want to fund and participate in these innovative delivery legal services. They have no plan whatsoever to play fast and loose with the attorney-client relationship or interfere with the professional judgment. But guess what? They didn't go to law school. They didn't have a clue what those things are. So if you want to allow fee sharing with them, can we at least require that they undertake that, have a training on the rules of professional conduct, and be subject to CLE. This one also has bracketed in it a percentage limitation on the aggregate ownership of the non-lawyers. And Neil gave us 2 hypotheticals last time about fee sharing. One which would help access, and another one that would be very scary because it sounds like who knows who would come in and take over the practice of law if you allow complete 100% non-lawyer ownership. And so this has a limit on that, which is how some other jurisdictions have approached it. If there's a comment about this not being an open door for running and capping, and the most recent thing that I kind of implored Kevin to add was something that is borrowed from the disbarred lawyer rule. In California, disbarred lawyers can actually participate and professionally associate with a lawyer or law firm in delivering legal services. But the law firm that's doing that has to give notice to the bar when they hire them, say what they're doing, how they're supervising them, and even tell the clients who are receiving services being delivered through the participation of that disbarred lawyer that in fact is happening. And so the other thing I asked Kevin to add was, can we at least include something that says if you're fee sharing, you got to tell the bar, and you got to tell the bar how these people are assisting in the delivery of legal services and how you're supervising them. And so this is different from Alt 1 or Alt 2. This has a lot of public protection aspects to it that weren't there before. But I still think, personally, that you're going to have it attacked by both advocates. The ones who say this rule is the main obstacle to innovation and access will say you've really constrained it to the point where it's not going to help. You have Professor Bundy's letter to us saying exactly that. But there will still be people who say the exact opposite and say, I don't care, Randy, if you're limiting the percentage ownership, or that they have to tell the state bar, or that the non-lawyers have to be educated in attorney professional responsibility. I still don't think this long-standing prohibition should be taken down. You haven't made the case yet for why this should be allowed. And so, because I think it might not be viable, if I were a member of the task force, I probably wouldn't move its adoption. I would probably only move the adoption of the A5 right there on the board. But we wanted to have on record that before we considered it and rejected a rule-based approach, because there are folks out there, Arizona is saying we're going to take the whole thing down. You know, we have a measured and considered approach that is on record with what this task force did. And I let Kevin
add the things that I left out.
Okay, I have very little to add. I thought Randy did a great job of setting forth what was done in that memo dated December 26th that was in the materials. But given our discussion regarding Sandbox and how a lot of what would be accomplished under the rule can be accomplished in the Sandbox, which seems to be a preferred approach to doing this, I still think, though, that B5 is an important...
A5?
I'm sorry, A5 is an important revision that we could probably recommend be implemented even without the implementation task force, that it could be done sooner rather than later. I don't think you necessarily have to wait for it. So what I would like to do is make a motion in light of the fact that the December 26th version is, since it doesn't please anybody, apparently, and probably would not be something that's going to fly anytime soon. I would not want to lose A5, so I would like to make a motion that we approve A5 for consideration, perhaps even by COCRAC, and that it might go out for public comment sooner rather than later.
I'll second.
Okay, A5, does everybody have the separate?
No, we have it on the screen.
Okay, so it's up on the screen, and that's been moved by Kevin. Is there a second?
Second.
Okay, thank you, Tara. Discussion about A5 or the motion generally. Joanna?
I'm only wondering if we need to send it back to COPRAC, or can we just send it to the board for public comment? That would be, there's no reason to send it back to COPRAC that's real obvious. I think we just skip that phase.
I didn't take you're sending it, our sending it to COPRAC to be part of the motion. You're just moving.
I didn't intend that. It was just a possibility, depending on what needed to be done.
Right. Toby?
Yeah, I mean, in response to that one, I think if we tell the board to send it out for public comment, there's got to be somebody who's going to look at it when it comes back from comment, and we won't be around.
Yeah.
So maybe the discussion needs to be that public comment for COPRAC to consider later, but somebody has to look at it.
The board, when it goes out to public comment, the board looks at the public comment. It's presented by staff, and they make a decision from that point.
Usually there's somebody, at least with rules in the past, there's always been a review of that.
I think the floor here is that we recommend that the board explore this rule change, and that because we haven't put it out for comment, it wasn't in this form when we went out for comment with Alt 1 and Alt 2, that of course we would anticipate that the board would want it to go up for public comment, but that's for the board to decide. Do they want a staff working group? Do they want to send it to the Access Commission? Do they want COPRAC to do it? The board should not have any sort of blinders on from us as to who looks at it afterwards.
Okay,
And finish. First of all, as a longtime legal services person, I think this is wonderful, and I would strongly advocate for it. And I think it needs to be clear in taking this vote that this is without prejudice to other issues under 5.4, that this is a standalone piece of an amendment to 5.4, without saying we're not going to, by doing this, we're saying this is the only discussion of 5.4. That whether it goes into a sandbox or we have other discussions, I think sandbox is the right place for it. If that's still to be decided, I assume that's part of the motion.
Johan.
This seems to be confining it. All right, so we've got the changes, I understand that. Don't even really have a problem with that. I would still have an issue with that it's limited to not-for-profit organizations. So are we diving into this as a whole, or have we somehow accepted the rest of this as is and are skipping over those points?
As I understand the discussion, we have decided that rather than taking a wholesale revision of 5.4, that we are leaving next to the sandbox. And for the testing of what works, what doesn't work, for the regulator and all of that, so that in the future, we may revise 5.4 based on the experience, but we're leaving the issue of 5.4 generally to the sandbox. But because this piece, everybody, I think there's generally a perception that it's very valuable, that we would recommend this not to, without prejudice to, any future consideration of revisions to 5.4, but we are convinced, the motion is, this is a good thing, so we ought to go forward recommending that to the board.
Understood. However, doesn't it also, if I'm reading it correctly, and maybe I'm not, it also says that if you're a for-profit, you don't even go to the sandbox.
No, this has nothing to do with sandbox.
Okay.
This sandbox is going to be completely separate. It is going to deal with, it's going to specifically address issues of fee sharing and non-layer ownership. But this is, the rule as it currently stands, it would be, the motion is that it would be adopted into the rules of professional conduct as they stand right now. Toby, did you have something you wanted to add?
No,
Mark.
So you have taken care of one of my concerns by requiring that the nonprofit be a section 501c3 to deal with a lot of the abuses that exist with lawyers sharing fees with nonprofits. But the other one is still on the table. If we were sharing fees with lawyers, we would be complying with Rule of Professional Conduct 1.5, which would require disclosure to the client and consent. If we have a settlement that's approved by the court, and there's a sharing of the fee with lawyers, the court has some oversight of that. They'll be aware of it. And if there's any abuses or lack of communication or lack of awareness by the clients, the court will take care of that. We're in neither one of those situations. It's strictly a private settlement. And there's a sharing of fee with the non-lawyer entity. What protections are there to the client that that's occurred and that the terms are fair and reasonable and that the client consents?
Terry?
I actually don't know the answer to that. I have a separate thought. But I thought the answer was within the rest of the code because I thought the code already required you to reveal all of that stuff.
There is no requirement to get client consent for sharing fees with non-lawyers because it's not allowed. But if we're going to have settlements outside the judicial process, these are private backroom settlements, and we're going to have fee sharing with non-lawyers, shouldn't the client be aware of that fact, and I don't know whether they should have formal consent or not, but that would be true if it's sharing fees with lawyers. So I'm just concerned, I would not go down that road if I thought there was some oversight. And let me just throw out the other reason why I bring this up. It isn't just a fee sharing disclosure issue, it's a conflict of interest issue. Because as you know, under Ramirez versus Sturdivant and other cases, there are lots of opportunities where lawyers and non-lawyers can put their own financial interests ahead of those of the client in negotiating the client's part of the settlement, and then the lawyer fee will be done separately. And sometimes there's abuses and sometimes there's not. At least in many of those cases, the courts would say, well, you've got to get our approval for that, just to make sure that you put the client's interest first. So I'm just raising the question, and I'm actually more important in terms of more practical experience than anything else, but in the nonprofit field, where the agency has now gone out and hired a law firm, and there's a whole kind of a fee arrangement there, should there either be some oversight of something, some nature, or at least some disclosures and consent to the ultimate consumer? That's my question.
I guess under the current rule, it seems to me that's not required, because it just says if there's a fee ordered by a tribunal, so the fee is ordered to, the law firm that handled the case. And the law firm has a side agreement with the legal services program that says whatever fees we'll get, we'll give you 20% of it. Or we'll give you all of it, which some of the pro bono lawyers firms do. There's no consent there, so that's the existing law. The only thing this does is say that same thing is true, because there's no court oversight on that. What this says is even if it's not ordered by the court as a judgment, but rather as a settlement, you have the same rule. So this isn't changing that.
Yeah. Heather, and then Tara, and then Kevin, and Alan, oh my goodness.
This is just more for my clarification when it comes time to vote on this. Are we not discussing, so in the memo that was circulated, the December 26th memo, there's an A6. Is that off the table?
At the moment, it's off the table.
Okay.
The motion goes only to A5.
Perfect, thank you.
Tara?
I did not want to narrow it to only 501c3s because there's a number of other types of nonprofit entities, and so I would just, do we want to narrow it to only 501c3s?
Kevin?
To address the issue of narrowing 501c3s is the issue that Mark raised, is the abuses that can occur. We want to limit it to something, and this is modeled on the DC rule, which expressly recognizes that there are abuses that occur in the settlements if it isn't with a 501c3, that there are other organizations like unions. If you look at, there's about 20 different types of organizations, nonprofit organizations in the Internal Revenue Code, that are not things that you would want to have people doing this, or there could be nonprofits formed by the lawyers themselves, which has been done here in California. So we're trying to avoid that abuse. It's a shorthand method of doing it. And if you can point to a specific non-501c3 with whom a lawyer would regularly share legal fees, if there is lobbying going on, they often have like legal services, like ACLU.
ACLU Foundation
has a
is
foundation
that's used in the memo.
so that they can share fees with lawyers and so forth. As to Mark's concern about the oversight, you still have the rule dealing with unconscionable fees. That in itself is something that prevents those types of abuses that you might anticipate might occur. It's still just the sharing of the lawyer's fees, not the client's judgment.
Alan?
One thing I was about to say was the unconscionable fees, which Kevin already pointed out, but is an example of a different nonprofit, 501c6, for example, all the lawyer referral services. Many of them are 501c6s that currently share fees if they're state bar certified with attorneys. So maybe there's some language that we can borrow from there to kind of address your concerns, Mark, because that's already
I
very
also
well
agree with the
established.
501c6s, and they're also professionals, so they're held to their own.
C forms as well.
Okay, it's lunchtime and it's entirely unclear to me where we are. Do people feel they're ready to vote on this? Is there a proposed amendment with respect to the 501c3, Randy?
I would kind of leave 501c3 alone. I think Toby looked at it for us in between meetings. And regard to lawyer referral services, they have actually their very own exception for them. Now, Jackson versus legalmatch.com put aside, but they have their own exception right now. More towards Mark's point about what is essentially a client right to know issue, part of me says what the court said in Fry versus Tenderloin Housing Clinic is that when it's non-profit, the risk of abuse is a lot lower in general. And so since we've limited it to nonprofit, and we've even sort of hung a lantern on the fact that we want this to focus on IOLTA recipients and legal services, I feel kind of safe with it. But out of abundance of caution, if you wanted to, you could add a comment to this rule that says, depending on the circumstances of the fee-sharing arrangement permitted under A5, it may constitute a significant development under Rule 1.4 or Business and Professions Code 606A that would require the lawyer to inform the client. And then if there was something crazy out there and it gets reported to OCTC, they have a charging vehicle. They can say, well, this was something that came close to being a conscionable fee the way it was divided. It didn't cross the line with conscionable fee, but it certainly would have been something you would have treated as a significant and told the client, since it did it for the client, we can discipline you. And I don't know, is that sort of half a loaf, Mark?
That's a half a loaf, all right.
Gavin, do you accept as a friendly amendment the adding a comment calling it a significant development under certain circumstances?
I think it deserves a comment.
Okay, all right, so are we ready to vote? The motion is what's on the board plus a comment that indicates that under certain circumstances it may constitute a significant development that needs to be communicated to the client. Okay, Mimi.
I don't have a motion, nobody made a motion second formally.
Yes, it was Kevin's, and then whoever seconded it.
It was Tara.
Tara, is that a friendly amendment, Tara?
Yeah.
Okay.
So I guess I can give it up if I.
Okay, Andrew Rita,
Yes.
Sarah Plumey, Tara Bird.
Wait, it's not here, it's here.
Sorry, I didn't hear Andrew's vote on this.
I said yes.
Okay, yes.
Tara Bird. Yes. Judge Wendy Chang, Abhijit Sivan, Gene Clausen, Johan Drolsagen,
No.
Margie Estrada, Lori Gonzalez,
No.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Raby,
Yes.
Toby Rothschild,
Yes.
and Alan Rodriguez,
No.
Dan Rubens,
Yes.
Mark Tuft,
Yes.
Angelina Belverde, and Joshua Walker.
Yes.
Thank you.
Lunch. Thank you all so much. We are on agenda item number 2, and the next topic up is Johan's favorite topic, 5.7. But before we go there, does anybody else want to be heard in any respect with respect to 5.4? Johan.
Are we done talking about 5.4?
Well, I guess you're going to tell me.
Okay. I'm never done with 5.4. I love 5.4. I thought a lot about this, and I was even considering writing a memo to submit just to help it knowing what the challenge is. I and a few others vote against it because it limits down to not-for-profit. What I'm suggesting is the solutions for 5.4 run a pretty big spectrum. And just to knock them off, one of them is don't touch 5.4, which nobody really argued for. Maybe there's somebody out there that feels that way. One of them is alternative 1, which is what it is. The other was the client consent model, which we got huge amounts of support just for considering, and I'd hate to walk away from it and it not go to the next level, at least for consideration. And then the other is my personal favorite, which is just eliminate 5.4 altogether. And we've sort of got a concept of into the sandbox arena. Is it reasonable in the recommendation to suggest that anywhere on that spectrum an actual decision and follow-up work could be done? Meaning literally represent the full spectrum as opposed to just one improvement or one anything else. I looked at this from the beginning, and every morning before I come in here, I read that the charter again, and I know we're trying to get there to where we do the straight recommendations, and I know we're not supposed to be wordsmithing the rules, and yet we have 16 wordsmithed rules as recommendations. I just feel like the entire conversation of 5.4 should go forward to the next level, as opposed to just the section we just discussed or not coming up with a suggestion, but a suggestion of the entire conversation should move forward.
You mean should move forward in some form other than the
Within the recommendation.
The sandbox, which is intended to address either relaxing or suspending 5.4 with respect to applicants in the sandbox.
And I think that could be included in it, but I think 5.4 is the crux of a lot of this. And I guess what I want is the Board of Trustees, I want At-Tills 2 or the Commission, and even the court to understand how hard it was for us to not put a nail in this. You know, to say that this is a finite thing that we all agree in consensus that we should do. It's a big concept. I just want that whole conversation to move forward.
Yes, Bridget.
I agree with that, but I do think that we would be moving it forward with the sandbox because at least the way I read it, and I definitely want to refine what we've got written here, but it would be looking at 5.4, but in a way that we can understand what's actually happening with it, and then the phase 2 of the sandbox would be to make some kind of recommendation, taking all the information into account that they've been able to gather over 2 years of regulatory sandbox as to what to do with 5.4. And my understanding as to the reason that we as a group have moved towards the sandbox to begin with on these issues is because there are so many unknowns with just tweaking the language, and so we want to take what Utah's doing and adopt that here so that we can actually see what the risks are and to write the rule around something that we know about as opposed to now, which is something we don't know about.
The only thing I would add there too, I think we have a cold start problem with these modifications because in some ways we continuously are trying to understand what could happen and what are the ramifications of us changing the language, whereas the sandbox will provide us with the data we need to be able to see how severe the language change if it could happen or if we should abolish it outright. Now, I think without having that data, we're likely not to get anywhere with any proposed changes to the language, or we're striking it outright. And that's why I think to just double click on what Bridget's saying, I think that's why that regulatory piece going first is so important.
And we could do, as we talked about, as Randy mentioned, with the other language of the new language that Kevin had helped put together. I think in addition, the alternative 2 would go in there. Like somehow I envision the report would say, we considered all of these different alternatives. Here was one, here was a new version of alternative 1, here was alternative 2. We talked about all of that, and after considering all of that a lot, we feel like the sandbox is the way to know how to actually address 5.4. I don't think this is any attempt, to just forget about 5.4. I think that's exactly what this sandbox is all about to me.
And then the last thing I'll say is, I envision a world where after, say, a year of the sandbox, you might be able to say, hey, we learned how Rule 5.4, we need much stricter language. I mean, what we saw in that sandbox was horrific. There was abuses of this, and or alternatively, it could be a situation where there was no harm produced, et cetera, which would mean a severe relaxation or an outright removal of it. But without that knowledge and the data from it, we won't be in as strong of a position to truly be able to put some meat on the arguments for or against any of these changes to this rule. At least that's my opinion.
Lori and then Joshua.
So I want to kind of back up for a second and say, I know last meeting there was a lot of discussion and there was a clear divide, and then the sandbox is really where everybody got comfortable. I just want to point out that I would not have been in agreement with the sandbox idea without having some structure that we could borrow from Utah, so I think we got very lucky there. And to Johan's point, what I think that is fair to consider as an ask of this task force is there were a large number of people on this task force who were in favor of a change to Rule 5.4, and struggling through the language is where we got caught up. And so I'm not suggesting that we don't do the sandbox, but I actually think that the idea that this task force saying Rule 5.4 was too big for this task force to consider, but it should still keep moving forward in the discussion and not just in the sandbox. And one of the reasons I say that is we know that Arizona is actually looking at doing away with that. And this next group may actually be informed by what happens in Arizona in a way we can't even imagine yet. And simply by saying, even us saying we've considered everything and this is the safest approach we could take now, has implications in how people address this moving forward. So by approving nonprofit only for Rule 5.4, by approving the change we just made, and then refusing to take this discussion forward, we do say in some part that those words in themselves have informed people moving forward that this task force somehow, the impression could be given that we don't think eliminating or changing 5.4 drastically, except for in a very regulated sandbox, is the right call. So I think what I'm suggesting is, I'm with Johan on the idea of, it doesn't have to be that we say 5.0 is a good idea or a bad idea. We had a lot of discussion. We simply didn't have enough time, and we don't have enough data. I'll share that the sandbox still scares me because we do have data that says fee sharing doesn't cause harm. Washington, D.C. is our data. And yet this task force could not get past potential harm that could happen. So we couldn't even get to where D.C. has been and has been for a long time. So the sandbox could have the same effect. If no one shows up and there's not enough impact, we could, people down the road could then say, well, the sandbox is a perfect example of why 5.4 won't make any waves if we change it. So I think I'm with Johan. I'm actually just suggesting that is this task force willing to consider a very small statement that says 5.4 was too big for us, and we think that conversation should continue moving forward.
Okay, I've got Joshua and then Tara.
On a very much related point, I just want to read the report segments that were quoted to call the question that we've been asked. And it says, this is from the landscape report, under ethics rules, any business engaged in the practice of law must be owned and controlled by lawyers. This prohibition limits both the opportunity and incentive for non-legal entrepreneurs to enter the legal market. Second paragraph, By modifying these rules, we will facilitate the close collaboration of lawyers and non-lawyers. The legal profession will accelerate the development of one domain productized legal solutions that will drive down overall costs, improve access for the poor, working middle class, improve predictability and transparency, yada, yada, yada. So that's the question we were asked that inspired this whole thing. I don't think we can avoid that. I don't think we're trying to avoid that through the sandbox proposal. But I do think we made a mistake earlier on, and my vote reflected that, by talking about eliminating rules, because I think what that did is it provoked a lot of, there's a lot of legitimate criticism and a lot of legitimate public comment that we've carefully considered, and there is a lot of fear. And the biggest fear that I heard was that people are terrified that Amazon is going to take over their job. And even if that is not the case, even if they are much more at risk of the current status quo and consulting and audit companies out-innovating them in related spaces, which is a huge risk of the status quo, we have to protect them from that as well. And even if we are not here to protect lawyers per se, they're an important interest group, and I think we have to consider that fear, and that is not helpful to promoting and getting people on our side to make positive change, to help the poor, to help the needy, to help everyone who's a citizen of California, or otherwise who's living in California. So I just think it is worth emphasizing in the sandbox that we want to help promote outside investment in law firms in a carefully regulated environment. I do think we should talk about it in the sandbox or in general, but I don't think we should use the words like eliminate, because it terrifies people unnecessarily.
I agree with Lori and Johan, and I do think that we should keep it outside of the sandbox. I mean, it can also be part of it, but should also be a separate track, because we don't know how that's going to go. And I think Lori's proposal was on point about just having a paragraph that says, we evaluated it, maybe, some of the ideas, the bullet points that came out of our discussions about the types of people and the very specific ways that we thought that the changes to 5.4 could be used, because we did go over that, and it's probably in our reports. I mean, I forget what they're called. Incubator programs were one of them, churches were one of them. I don't know that the changes we agreed to today addresses those, but I think that should go in the proposal with the consideration of whether other nonprofits and other types of business entities would meet the requirements. I just think that I agree that it needs to be in there for the record.
Okay, we got Andrew, and then Heather, and then Kevin. Is that a scratch or a sign?
I guess I want to maybe clarify and agree with one of Lori's comments that if this is all our recommendation on Rule 5.4 is this small change, I agree others might take that as a non-endorsement of any other potential change to Rule 5.4 down the road. So maybe what we need is a recommendation that would survive a sandbox that essentially says if it's determined in a sandbox that that 5.4 does not actually protect consumers. In other words, there are activities in the sandbox that operate under a relaxed or eliminated 5.4, and there's no harm to consumers at all, then what is the remaining purpose of 5.4? And if we have a recommendation that says in a sandbox that we collect that kind of data, then maybe we do recommend a relaxation or elimination or some more major change to Rule 5.4. I think this rule is a major impediment to access to justice, and I think we need to do something about it.
Can I address his comment directly?
Heather's next up, and then you can address it.
I just want to go on the record as well as agreeing that 5.4 I think needs to be explored deeper. Coming from inside the law firm, I will say my experience is that innovation will never come out of a law firm until we get capital into the law firm and get business people and the innovators and people with the ideas into the law firms to take those ideas and start to expand them. The lawyers are not going to be doing this without it. We need the lawyers involved in it. So if we want the innovation, we've got to get the capital into the law firms.
Tara.
So I'm hoping that someone's gonna volunteer to draft this proposal for next week.
I'll absolutely.
Oh, awesome. But just to respond to Andrew's suggestion, I think that the sandbox proposal should reference 5.4 and how what comes out of that, the 5.4 should be reconsidered. But I think the 5.4 separate proposal should not reference the sandbox, because then I think people might look at it and be like, oh, put on hold, let's go this direction. So I think that should be inclusive of 5.4, but 5.4 should not reference the sandbox, just for drafting purposes.
Okay, so it's Kevin and then Simon.
Okay, I have to admit to a bit of skepticism. That investment in law firms is going to increase access to justice, their investment. And I just see that as a disconnect. Slater Law Firm, Slater Gordon in Australia, is a personal injury firm. And yes, you borrow money, but the type of access to justice, the people who we're talking about who aren't being reached, investors invest money to get a return, don't they? Where is the return in providing legal services that are not being delivered right now? I mean, I understand you talk about this concept of ideas. Okay, fine. No, please enlighten me some more. But I think the people around the table have been very helpful in helping me appreciate the problem and so forth. But just this talking in general terms about investment, capital, and that it's going to, increase innovation and so forth. Give me some specifics. Give me examples as to what you see is going to transpire going forward in the future.
I don't think we have to. I don't think we have to though.
Okay, but please,
I think we need to provide examples of why it wouldn't. Because you flip, it's this constant debate of like prove it and prove it. It's like, I'm sorry for jumping the line.
No, I just want to
I just don't think we need to do this prove me thing. It's just,
I'm not asking you to prove, just give me some examples that I can appreciate and not just talk about general infusion of capital will increase innovation and will increase access to justice. Because I've also heard people talking about before when Lori was discussing the paralegals and saying, well, if lawyers haven't figured out how to make this business model work, how are paralegals going to do it?
Without investment and others to bring in the knowledge that we don't get taught in legal.
Okay, Simon, you're up.
All right, so I'll provide an example, and it's quite personal to me. I spent a year and a half with a tech guy called Spencer Simonson. Andrew has met him, and Lori has as well. And we spent a year and a half building the very first software that automated filling out a form to help Indigenous, oppressed, poor people access the small claims court in San Francisco. That software is collecting dust because we could not get any money. We could not convince a single VC to invest in this. And I'm fucking broke because of that. And we had to shut it down. No one is using that software. It's great software. This engineer who makes, God knows how much money, also left his really luxe LinkedIn job because we care about people and and that's the only reason why I serve on this committee is because I want more people who just really care to have these opportunities. And in almost every single outside investment or in VC meetings, what are the legal challenges? What are the regulatory challenges in UPL? Also, non-ownership with lawyers. It was. I couldn't hear what you said. I'll speak up. And so, to me, there are those guardrails in place because people who have lots of money are also not stupid. Some of them may be more stupid than others, but they also want a good return on their investment, as you said. But right now, because of all the hurdles that we've had, I would love to give this software away for free, but there's this general skepticism about what my intentions are. And I understand that there are predatory things and we need to protect that. But to me, I would love to do this. And in the end, obviously, nothing came of it. But I want to make that impact. And I think there's a lot of younger people out there as well who have that eagerness. And I would love for this committee to continue to think of ways that we can support them and make it easier.
Yes. Okay, so it's Alan. Joshua, did you have your hand up?
I'll wait for now, thanks. That was well
Okay,
said.
Alan. Just another example of how this doesn't have to require necessarily big capital investment. So you could use a personal injury example. They've already got litigation finance and they're pretty well set with that. We help 1-400, my company helps build subscription-based platforms that allows law firms to offer their services on a subscription basis. Many of the firms that are interested in that are smaller firms that service the lower end of the market, right? When we build that solution for a solo practitioner, and we have several examples, you can go to BeverlyHillsLawCorp.com and see one, that cost that solo practitioner, he had to reach really deep in his pocket. And that solo practitioner, well, I'm not going to finish that example. Another solo practitioner had previously asked, well, can't you build this, and then when we start selling the service to customers, I can pay you back then? I said, no, obviously we can't under the current regulation. But if the rules change, then organizations, not just like mine, but organizations in general, can then partner with the people that want to serve that lower end of the market and that have technology capabilities and they're willing to invest because they're good people like Simon suggests. We want to see, better access, right? Some of these subscription services sell for like $49 a month, $25 a month to get some access to legal advice, document reviews, letters or phone calls on your behalf to, say, resolve everyday issues like warranty repairs or something like that. But building those technologies to allow firms to do this is very expensive. And I certainly, speaking for myself personally, I certainly would be interested in investing in the right law firm that has the right mindset and the right drive to do it. But I'm out my money until I can collect. So I have to collect it from them up front. And if they can't afford it because they're a small solo firm trying to sell a product at $49 a month, it takes a long time to get that money back, right, in terms of volume. So litigation finance and capital investments aside, I think that's a more realistic example that I come across every day in my line of work.
Okay, just to clarify what you just said, Alan, would you want to invest in just one law firm that's willing to do it, or would it be more than one?
I don't know, the possibility's not there. I would like to keep an open mind and says anybody that brings a great idea that we can get behind and that we see a monetary return in our investment, like any other investor, like, yeah, I'd like to partner with them on some concepts.
The economic answer, I think, to extrapolate out from those very specific examples, and I think the others are, two answers. One is the fixed cost requirement and zero marginal cost. So when you build a technology infrastructure, it's expensive to do it first. But if you're in India, the big companies are going to pay for it. If you're in sub-Saharan Africa, same thing. It's going to start with mining companies and others. But the entire populace can then get access to that. So if you look at the cell phone revolution, it's the poorest have benefited the most in some ways. There is an analog for legal services. You're right to be skeptical. That's why we can look at an empirical. We can ask those hard questions to specific people. But that's the fundamental thing: is high fixed cost projects with zero marginal cost, where each additional user can get it for free or near free.
Okay, Joyce.
So I'm going to tell you about Quest for Justice, which is a brand new organization that is looking to build automated tools in LA, which I think is Orange County. Don't yell at me about geography in California, as we know that's not my strong suit. But they are, the co-founder is Patrick Forrest. He is a former VC, so venture capitalist. He has $5 million for 2 years. And he is coming to California because of this task force, because they have the volume, they've got the population, and they're looking at regulatory reform. So there's an example of somebody who's sitting on the sidelines, kind of waiting to see what happens, ready to come in, who is venture capital money. I mean, that's his money ready to go. The other thing, because I get to talk about, I'm got the floor, and I get to talk about my organization, the Florida Justice Technology Center. In year one, with the Florida name change tool, we served 1,035 unique people. Year two, with a 12% growth rate, we served 3,492 people, which roughly, at $20 a pop, would have been $70,000 coming into our coffers. And at a 12% growth rate over the course of, now granted, there's a limited number of transgendered individuals, but in Florida, we estimated based on data from the Williams Institute that there were 110,000 people who self-identified as transgender. We know those numbers are higher because people don't always open up about it. So there you go.
Okay, so I've got Heather and Lori, and then I would like the floor to try to wrap this up because I think we can move forward.
I just want to give an example from corporate law. So, we work in the banking industry, and we get a lot of repeat business and a lot of things that we do. And so we've been able to start putting some processes behind that. We figured out a way, and we're trying to build out a software because we realize that our clients don't want to pay us any money anymore, but we're trying to build out a software right now that we could then turn around and sell to small law firms and solo practitioners so that they can actually do the work. And it's working, with people who are in foreclosure. So there are things that we're doing that we're seeing that we can put a technology behind, but that's going to cost us a few $100,000, if not more, to build out that product, and we don't have the capital to do it right now. So it's in a way, it's in this little hold position within our firm that we have the idea, we kind of have something built out, but it's really not something that we can turn around, package and sell, and get that work out to all these people who can then help other people out there. So that's just one thing that's going on because we're seeing we're seeing what's going on and how you're practicing law and how that can impact others. Work's becoming more and more commoditized, but the innovators or the people who have the ideas are within the law firms right now. They're not the innovators, they don't have the capital, and that's what we're hoping to see too.
Lori.
But I think hopefully I'm going to help bring it back around to justice. One, I think I actually agree with Andrew. Like, we can give you lots of examples, but at the heart of this, we don't ask those same questions when we all just voted on giving money to nonprofits, fee sharing. We voted on Rule 5.4, and no one asked those same questions. Why do those nonprofits need money? We all recognize to continue doing any sort of business and make change and offer new services, you need money. I don't think that's up for debate. So I just want to kind of bring it back to, as a task force, are we comfortable enough with a paragraph or a note that says, as a task force, there was a majority that believed Rule 5.4 impedes innovation and access to justice, but we were unable to really get to a place where we could agree how Rule 5.4 should change. And we think that this discussion is important enough to continue moving it forward regardless of a sandbox approach. And so I think that's what I'm asking the task force to consider, and I'm happy to work with Johan to put together some language on that. Not that it should be eliminated. Actually, that wasn't our proposal to eliminate it. I don't think anyone who is in favor of relaxing Rule 5.4 on this task force thinks it should be so Wild West that there's no oversight. So maybe some of it.
Two people excluded.
But at the end of all of that, I think there was a lot of discussion. I think everybody moved in some way forward. Kevin informed me in lots of ways as well. So I'm just asking the task force to consider a paragraph that acknowledges 5.4 could not be resolved in this task force because of our time constraints and blah, 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 but not that I'm afraid if we only make this one small change to 5.4 that we make, and then we only reference the sandbox, that actually informs the public that we maybe thought 5.4 should remain in place.
Okay, if you keep it really short.
Sorry, very short. I wasn't trying to ask you to prove to me that this works. I was asking for examples and provided examples. I say that if you use the word open up investment in the report, provide the examples that you gave today. In other words, use those, because what do lawyers hear when they hear investment? They hear Sears, they hear Amazon, they hear
Disney.
VCs, anybody who is going to come in and take over the legal profession. It's people who are just going to come in and all they want to do is strip the bones and take away any profit. And that's the problem. You use these terms, you talk in capital, you use economic terms, and yeah, we can all understand them. But you have to talk about the real life situations, because remember this, we're talking about access to justice on this task force. And there is that disconnect for a lot of people here with me, but this is very helpful, the discussion, to give me examples of this. It's not proving anything, it's just demonstrating this is what we have in mind. Okay, sorry.
Okay, Andrew, it's only because I love you.
Yeah, all I have to say is the AmLaw 200, the way that they benchmark is profit per partner. That's it.
Okay, this is how I was gonna suggest that we wrap this conversation up, because we obviously, over the course of, what is it, the last year, have debated 5.4 at some length. What I hear around the table is a desire to make it clear in a paragraph that by simply adopting the sandbox approach and making this limited change, it is not a message from this group that people shouldn't continue to look at potential changes to 5.4. And I think that's a good suggestion. So Lori, you and whoever else can work on a paragraph, and then we'll bring it back to the next meeting so that we can talk about what it ought to look like. But I think that's a good idea, and I'm sorry to cut off debate, but we do have these other things that we have to get to. But I really appreciate all of the, I will second what Kevin said. I think these are helpful, healthy discussions. This is what we're supposed to be talking about, and so I'm sorry that we can't spend the rest of the afternoon talking about it. Oh, Tara.
I just want to make sure that we have maybe one of our really excellent wordsmithing attorneys maybe review it after they write it, so that we don't come back to the next meeting and be like, well, just so that they can get all those ideas feedback back to you guys after you draft it. That's not an insult to you. Joyce and I struggle with the same thing, and we really need someone who thinks the way, Mark.
Kevin, can I volunteer you? Okay, so Kevin? All right.
I have a quick question. So who is assigned to that? I know earlier Johan, Lori, and Joshua, I think, raised his hand.
I will see the floor to Kevin, that's fine.
Okay.
No.
Okay.
I'm not one of them.
Thanks for letting me do that, Justice.
All right, here we go. We are now up to 5.7. What excitement. Kevin and Mark, you want to take over on this?
I thought that, we wrote a memo which outlined the proposal that, although we've not drafted a change to 5.7, that it ought to be among the recommendations we make, that it ought to be looked at, because it's part of the solution to narrowing the justice gap. And I think that the letter that Professor Bundy wrote exemplifies, builds on that. Just so you know, he's the chair of COPRAC, and he's the one that spearheaded authoring the ethics opinion on 5.7 that met with significant resistance by the Office of Chief Trial Counsel on some very important points. And so we've never had a Rule 5.7. I'm one of the authors of the original opinion back in 1995 that is completely outdated now and has completely been superseded by recent developments. And while you're all fussing around with 5.4 in the sandbox, see where that takes you. 5.7 is a proven rule, and it is being used today. All this investment we're talking about in technology and the law is occurring. The article the other day about $9 billion being invested in AI and the law is just an example of how fast technology is influencing the practice of law today, and there's no barriers to it. And law firms are among the greatest investors in intelligence and innovation of legal services. So that's not going to change no matter what happens. But there is no rule that gives guidance to consumers and to service providers as to where legal services and non-legal services meet. And we have, as I said the last time we had a meeting, there are many ALSPs that are growing very quickly across the country and across the world for that matter, which do involve a combination of lawyers and non-lawyers developing technology, developing businesses that fall within the 5.7 category. And there are a lot of abuses. As I mentioned in the last meeting, there's a lot of things going on in terms of outside entities now managing the practice of law that really would interfere with all the protections that 5.4 is supposed to promote. And so, as part of the solution in narrowing the justice gap, 5.7, I think Kevin agrees with me, is something that should be included in our recommendations. Professor Bundy's letter, I think, outlines how the rule is supposed to work, and that the next implementation committee should look at this rule, not only from the point of view of whether we should have it or not, but also from the point of view of what needs to change. And Kevin and I wrote as part of our memo that 5.7 in its original configuration never took into account the discussion we just had. It never took into account how the relationship between lawyers and non-lawyers can work today without creating an upheaval in the delivery of legal services. And so redefining what non-legal services are in terms of that combination of lawyers and non-lawyers would be very useful. Because it's going to continue. Whether they're in the sandbox or not, we're going to continue to have these combinations of legal and non-legal services with lawyers and non-lawyers providing technological services that's perfectly permissible and do not implicate the rules of professional conduct. And so as long as you have that dynamic going on today, 5.7 is necessary from a public protection point of view. And I think with that, I'll let Kevin speak.
I have nothing to add. Thank you.
Johan.
I agree. I like 5.7. I think we get a lot of other peripheral benefits from 5.7. Very specifically, the difference between practice of law, law-related activities, and non-legal activities. I would really hope to use those in consideration with the sandbox, because I think as I covered on 5.7 when we were originally responding to the comments, I think we improve access to justice and this would protect attorneys, or protect lawyers, that get into these activities, but will improve access to justice when we take the things that are included in the practice of law by default and take them to a lesser level. The example I used before was interpretation, which we now have machine learning that does translation, which can even be do-it-yourself type of format. So this should help us allow a regulatory structure to not only inhibit what I would call persecution of lawyers, being that they're just simply responsible for everything, to increase their ability by these tools, which are cheap to free, Google Translate being one that's actually just starting to charge, but it's such a $7 per 10,000 uses or something like that. This is what not only protects the lawyers, but it lets all the other service providers that have not been able to get into the game into the actual ability to serve in this arena. And it's I think defines the structure of what the regulatory body needs to look like.
Can I add one thing? There's a number of examples that were mentioned here a while ago about frustration in terms of allowing technology to work in the legal services business. Had we had 5.7, those things would have been allowed.
Yeah.
And you would have had those things, and your software would have been sold and used and would have been profitable for you. We need 5.7.
So, Mark, do you have a motion?
The motion is, there's two sets of rules here we don't have drafts of, because I don't think this committee is it's a policy committee. So I don't think we're in the rule drafting business particularly. But I think we do have a recommendation in our report, which recommends that this commission recommends that as part of the implementation of its report, that a group be formulated to study the 5.7 and whether it ought to be adopted and whether it should be changed to accommodate modern technology and the law-related services that we're seeing being developed today with lawyers and non-lawyers. As one of the alternatives that's available right this minute, with no sandbox, to narrow the justice down.
Nope. I'll second it if that was a motion.
Lori and then Andrew.
I think my big question was just, so a software company under 5.7, because I'm not as familiar with 5.7. Under 5.7, a software company who designs something that assists consumers with accessing the courts in some way, there would be allowed a partnership, investment, some form of connecting, partnering between a lawyer and a company like that if 5.7, some version of that were put into effect. Is that, okay, that I just think.
And that just goes on right now.
Andrew and then Andrew.
I think one of the things we were asked to do is what Mark just recommended. I think we need to go further than just saying that someone else should consider this as to whether or not it should be adopted. We don't necessarily have to draft it, but we should say, yes, we ought to, or yes, we recommend adopting, this version or a version similar to this, or a version that has these components. So I think we actually need to make a recommendation more than just, somebody else should consider this.
Do you mind if I take Mark before Andrew? Mark, you said yes.
There are a couple of complexities that's very hard to draft. You surely can't draft on the fly. One of the big issues, and not only in defining what is a non-legal service versus a legal service, which should be part of the assignment, and that's difficult. But the other big one that has been teed up, that's got the Office of Trial Counsel and the COPRAC at odds with each other, is where the combination of services involves fiduciary obligations to consumers. Because the state bar's Office of Chief Trial Counsel takes the position that when a lawyer's involved in that kind of service, the rules do apply. So that then defeats the objection I'm trying to posit here, is if the service that the combination of lawyers and non-lawyers are running to consumers involves some fiduciary duties on the part of the deliverer of the services, the state bar's disciplinary counsel says all the rules apply. And we're trying to develop a rule that says, wait a minute, there is a group of services that can be delivered to consumers today that don't invoke the rules of professional conduct. And lawyers and lawnmowers should be able to combine their services together, make a profit, and deliver those services without being bound by the professional rules. So how do you write that? And the answer is not easily. So it does need, and Kevin and I would have a great time doing it. In fact, we talked about doing it. But, in all honesty, I think it's beyond the charge. I think the recommendation should be to set this up and say, this needs to be looked at, and with a rule drafting committee that can spend the time to look at this and come up with a bona fide draft. But we can outline the issues for them, but I don't think we should do the drafting because frankly, it would take some time.
Andrew.
I'll withdraw mine. Well, I'll just reiterate, obviously the complexities of the ABA model rule in contrast with California law is well known amongst people who have undertaken the effort to try to draft a rule historically, as well as the Office of Chief Trial Counsel and many ethicists in California who understand the complexity of the law in this area. However, that being said, I'm very persuaded by the fact that the rule was written at a time when the issues that have been grappled with by this group were not understood, and I think a unique rule in California could do a lot. All that is backdrop to say it's very concerning to offload this difficult issue to another group who might be comprised of folks who are not part of the discussion of this past year. And unless Mark and or Kevin are volunteering to be on a second group, or if there was a specific drafting team, commission, task force dedicated to this issue, outside of those two things, the only other issue would be, approach would be staff or the current configuration of the Committee on Professional Responsibility and Conduct, and they're all excellent ethicists, but it's such a complex issue, I really think it needs specific focused attention. And all that to say, unless at the February 4th meeting or the February 24th meeting, some more specific outlining or defining what non-legal services means. These four issues have been raised, are great guidance, but I would agree with some of the other comments that have been around. I would request some more specifics, if that's possible, from either Mark or Kevin.
Mark, I think he's volunteering you.
Or
Kevin.
You're in trouble now.
Just when you thought you were out, they pull you
Kevin and I will talk, how's that?
Kevin, can you put together some examples too?
And I might have to.
And then you can tell me how realistic this is.
Kind of not really.
Randy.
And I don't know how controlling the recommendation has to be in terms of what we're passing in terms of the baton to a different body to continue the study. But Professor Bunde raises a point with regard to the differing views about the existing law, whether it's compatible with 5.7 or not. But one of the points he does make is when you're in a sort of a prescriptive legislative mode where the Supreme Court might be promulgating a rule of professional conduct in an area where there has been no rule, then you're not bound by the existing common law, what has come out of the State Bar Court or the California Supreme Court in different cases. You can rewrite the world as you see fit. And I'm wondering, based on what the two of you have looked at so far, is it your thinking that 5.7 could be pursued as a codification of existing California law in terms of the case law, and that would be enough to exculpate the lawyers who want to do these things and not have a fear of discipline? Or having looked at the issues, you think there are problems with the common law that should not be codified in a new rule that would still give enough public protection, but would unleash even more possibility for innovation in the non-legal services arena? Because I think that would be a very good signal to give the implementation or rule drafting body the benefit of what we've done on a limited basis with this rule.
Kevin and I will talk. But we actually will probably need staff's assistance.
So, Lori, I think was speaking in jest when she asked for examples. But maybe you can give a few examples, Mark or Kevin, of how it is that having a 1.7 would increase access to legal services. I mean, now.
I was just having a sidebar with Bridget asking the same thing. Like I'm struggling to see it. So
Joyce was asking me the same thing.
Okay.
It's like, what if it's non-legal services? Why is it that this furthers our purpose of increasing access to legal services?
Because let's go back to the beginning. There's lots of things that non-lawyers can do that if done by a lawyer constitutes the practice of law. And so to avoid having all the rules apply to what the lawyer does in a law firm or as a lawyer, the lawyer can create a separate entity, a separate business with non-lawyers to provide those what are now called law-related services. They can run from document review, document preparation to litigation financing, to mediation services, to the whole panoply of services that, if performed by a law firm, would constitute the practice of law and would bring into play all of the rules of professional conduct. So there are law firms out there investing large sums of money in technology to do all of the things that the accounting profession are doing, that other professions are doing, with other disciplines are doing, in a technological way, as a separate business. And they are performing those things as a separate business, and therefore are not within the purview of the rules of professional conduct. If they meet the standards of 5.7, which means you have to have a distinction between delivery of legal services under a law firm versus the delivery of these other services in a non-law firm setting, and you make the disclosures that you need to make so the consumer is not confused, you can do a great deal of services that benefits the consumer, particularly in low income and what have you, without implicating our rules. So it gets back to what is the practice of law. This is one way to manage that, with lawyers and non-lawyers combined together, making profits and delivering services through technology. And 5.7 can be drafted in a way that accommodates that.
Alan and then Randy.
Yeah, a question for clarification. So my former employer, one of the founders of my former employer, LegalZoom, was Brian Liu, and he's a lawyer. But because he didn't want to deal with the rules of professional conduct, he formed LegalZoom, right, as a standalone. So I guess what about, like, I don't hear enough. I guess the example for me doesn't convey enough difference from just starting your own entity. So you happen to be a lawyer, so what? You start your own entity and you don't follow. I don't understand how this.
Well, lawyers go into many different businesses. You don't have to, just because you're a lawyer doesn't mean you have to be engaged in practice of law in everything you do. Lawyers own and operate all kinds of ancillary business services, such as this gentleman's program. His software probably would fit perfectly within a 5.7 model. And he could have come to me or Kevin or someone else and say, look, I want you to invest with me. I want us both to get together and maximize this. It's going to help all these consumers. We could have done that easily.
But I know you were just using an example here. Could Simon retain some ownership of that?
Well, the ownership could be worked out. I mean, we could be co-owners. We could be in a separate partnership. We could have, I don't know. That's a business relationship. But being a lawyer practicing law doesn't prevent me from engaging in these other activities outside the rules of professional conduct. If I follow 5.7 correctly, I can engage those and by the way, this is what law firms are doing today. This is the AOSPs.
I see, maybe I'm still confused, but I guess what about the rules the way they are prevents, like, say my former employer, Brian Liu, he's a lawyer, he's still a licensed lawyer, but he was the founder of LegalZoom. Like, with the one exception of this fiduciary relationship that can arise in these other businesses, which would implicate the rules under one interpretation of the law. There's lots of things lawyers can do. In fact, some of the largest law firms in America own almost all of the back office, technological, all the things that lawyers use to deliver legal services can be owned and operated in a non-law firm business with lawyers and non-lawyers. And many of those services result in revenue that is shared primarily with the non-lawyer entity and not the law firm.
But I think to finish Alan's question, I think, is, so why do you need 5.7? If you can already do all that.
Because there's so much confusion. If you put a room of lawyers together in here, you would have a difference of opinion as to where the permissible line is drawn. I gave you an example last time we had a meeting of the abuses without 5.7. There's a two-firm model I told you about last time we met, where the non-lawyer entity runs the law firm. I mean, they do 90% of everything the law firm does, and they pay those lawyers a salary, no profits, and the non-entity gets 100% of the revenue. You talk about interfering with professional judgment. You're really marching off into a different area. You need clarity because technology is moving so fast, and you've given me many examples of people on the sidelines who want to come into California and team up with lawyers. 5.7 gives you some permissive permission and draws a line as to where the protections you have to give to consumers and the separateness that you have to maintain in your practice. And I think that is a consumer protection goal that can be achieved through this role.
Randy.
So in a way, we already have a very small precedent for 5.7 in the rules of professional conduct that were adopted operative November last year. And so among those rules was 2.4 that authorizes third-party neutral. So before there was a 2.4, if I was a family law practitioner who did marital dissolution for 30 years, and for the first 20 years, all I did was litigate them, but in the last 10 years, I became a fan of conciliatory, mediation, all different forms of resolving a marital dissolution without litigating it. Because I'm a lawyer, I have lost the rights as a mere mortal citizen to go out and open a mediation practice, because if I do so, the case law has said I'm still bound by all of my duties as an attorney, because that third-party neutral activity is close enough to the practice of law that I should be bound by them. But another company might not be. And so what if I just created a company to do my conciliatory marital dissolution and owned it? Well, I'd be still afraid, because I would think it's still too close and I would be liable to lose my license for doing it. And so 2.4 comes along and says, if you tell the parties, I'm not going to be your lawyer, and that I'm actually in the role of a third-party neutral, and if you want someone to represent you, you need to actually hire a lawyer to be your advocate, because what I'm doing is not going to be governed by the rules of a lawyer as an advocate, but might be governed by things such as court-connected mediation programs or the judicial standards for neutral arbitrators. There might be something else regulating me, but I'm not under my duties as an attorney. So for the narrow issue of that family law practitioner who says, I found a better, cheaper way to resolve marital dissolutions, I can open up a company and start doing it, you can. But for all the other things in the world that a law firm might innovate and think they can do that doesn't require a license, but their expertise has led them to the epiphany that this is a way of making things easier and cheaper, there is no rule. 5.7 is the rule that says, if you do it the right way, you're relieved of some, if not all, of the duties that you lost when you became a lawyer. And you have to worry about conflicts, you have to worry about self-dealing, you have to worry about fiduciary duties. And so, 2.4 has already cracked the door open. 5.7 could open it wide.
Well,
Mark and then Lori.
And we're not here just to protect lawyers. A lot of investors, innovators want to know.
Actually, we're not here for that at all.
Okay.
Good job.
And I'm a lawyer.
But they would, I would think business people want to keep it, lawyers would like to know, can you do this? Can you team up with me? Can we go into business together and maximize this great idea I've got in technology? Or are we going to run afoul of all these rules? So I think it helps the innovator, the non-lawyer, as well as the lawyer, and the consumer.
So I think I'm just gonna start by pointing out, I've spent this task force was not my first time redrafting ethical rules. I did that in my state as well. I was on some committees that did that. What I'm hearing about 5.7 is, down here it seems pretty simple, and then up there's a whole lot of ethical concerns and ethicists who need to get involved. I'm going to share as a task force member who spent months and months talking about 5.4 and zero time talking about 5.7. But the idea that this committee, I never believe creating a rule is what inspires people to do things. Rules by their very nature are prohibitive. They're not innovative. They're not designed, rules are not designed by their definition, they're designed to tell people what not to do, not tell them what to do. So I'm having trouble on, in the limited time we have left, figuring out how I could possibly catch up with all of this enough to say I can vote yay or nay. I would probably abstain from absolute confusion, unless it was something more narrow, like a paragraph recommendation that this needs to be explored further. That's just me personally, and if everybody else is on board. But if you're telling me that Rule 5.7 changes what would happen with Simon's project because it only informs lawyers that it's allowed, that doesn't seem like that promotes access to justice. That sounds like an education problem to me for lawyers. So I think I'm struggling. If that's already allowed, then we didn't solve the problem because lawyers aren't, I just think the more you add rules, the more lawyers get confused by this. And I know this because I sat in a subcommittee meeting talking for hours and hours about a comment to Rule 1.1, which does nothing but help lawyers feel better. That was the purpose of our comment, and it took us 2 days to come up with a comment. So I'm worried about us spending all that time on language when I'm hearing it's way more complicated than we could ever do. But I just throwing that out there.
Kevin.
Yeah, to address your concerns, Lori, I think what we're talking about, if you have a rule that lays out the framework under which you can proceed, lawyers would be more willing to do so. But we saw what happened. Okay, but we saw what happened just with the opinion, the interim opinion that was drafted by the State Bar's own Ethics Committee, COPRAC, and was opposed by the Office of Chief Trial Counsel, because the law right now is contained in a lot of different cases, which are subject to various and sundry interpretations. And one group interpreted them one way, another group interpreted it another way. Now, the other thing that Randy raised before is that maybe a recommendation, I'm not sure you can do this without going through a full-blown study. I'm not sure we have the time of all the case law again, and then we could just end up arguing around the table, the task force all over again. But it might be, if there were a rule that the Supreme Court approved that simplified things, that in effect, the problem is the fiduciary duties that lawyers owe, even if they're not in a lawyer-client relationship, they can still have a fiduciary duty, in which case they would still be subject to the rules of professional conduct. That's the case law. Now, if the rule said, well, that isn't applying, we could have a very simple rule that is very much like the model rule 5.7. Whether we can make that recommendation now, I can't make that recommendation without going back to the case law and reviewing it, and then we would have to have another debate. But it's still possible under those circumstances. So I don't think it's just an educational problem. Lawyers can educate themselves about the case law. The problem is that the case law is subject to different interpretations. And the rule would provide clarity. That's what the rule would do.
I think we're in agreement then, Kevin. So I don't think I'm suggesting that I know it's an education problem. I'm saying, based on what I heard today, it could be an education problem, but there's a lot more research to be done to figure that out. And as usual, every time there's a rule, you put a room full of lawyers together and they all interpret it differently. I'm always going to hesitate to put another rule on the books without a lot of forethought. So I think I'm just suggesting, I don't know where we're headed with 5.7. Me personally, I don't know enough about it. We haven't had any real substantive discussions in this on 5.7. There's a lot of materials and I did read them, and I still am just as confused after this conversation on whether it's needed. Sounds like it's a way to help ease discomfort at the existing rules and to make it clearer on what's allowed. But if you can't tell me today, Kevin, with all your knowledge, I'm gonna have a really hard time, feeling good about real rule language, I guess.
We got Leah and then Mark.
I would just say, and I'm not sure this is the goal or part of the charge of this task force, but for me, in this area, as I've gotten more educated about it, I've always been struck by this as sort of an equity issue, because as Mark suggested, and as the white paper that I believe was circulated to this group written by Lucy Grieca documents, this is rampant in the corporate law side, and in the lack of this sort of regulatory vacuum that currently exists by not having the rule, we further exacerbate the divide between the people law market and the corporate law market, where you do have innovation with the very high-end, high-capital law firms doing all these crazy, it was a fascinating paper to read to see what they're doing, essentially redefining what is law and what isn't law, right? Because it's contract interpretation, discovery. Those things all used to be done by lawyers. So you've exacerbated the divide by having a vacuum, which is an equity consideration, not necessarily the charge of this group. So I do think, as we think about how to wrap this up, and having a paragraph that suggests there might be a reason for further study, that might be a reason, because you do have sort of this shadow world going on that's not regulated, and we do have to be candid about that. And that doesn't seem fair fundamentally.
Yeah, a couple of points of clarification. 5.7 is among rules that we do have that are permissive. They're not prohibitive. If there are prohibitions, but they allow lawyers to do things that would otherwise be prohibited. 2.4 is another example of a rule that if you abide by the rule, there's things you get to do. So it's prohibited. It's not prohibited. It's permissive. The abuses are not limited to big law. You have the example here this afternoon of innovation that small firms can't easily afford to invest in. 5.7 will help small law firms understand what they can and cannot do in terms of investment. There's lots of ways lawyers can invest in businesses outside the practice of law that would not be permissible inside the practice of law. So small firms will benefit from 5.7. It's not just a big law issue. Yeah, there are abuses, but there's abuses at the small level as well. We have lots of non-lawyer managers that are buying and selling and operating law firms on the small level today in California. And that's a problem. And so it's not just a big law issue. And so there's a public protection for 5.7, I think. And I do think it does advance the access to justice.
Okay, it's this
Unless,
Andrew, and
if
then
you went to
that.
with 5.4, well, then this discussion is moot. But as long as you have 5.4 that prohibits the combination of lawyers and non-lawyers, then here is a alternative that you can operate today with very little difficulty, that is permissible in the case law. You can have a clarifying rule as to where some lines are being drawn, and you wouldn't waste any time getting more services to lower income people.
Yeah, I just wanted to double click on that idea about adding that paragraph as Leo laid out. I think it's really important because a lot of the firm examples of innovation, I pulled up the profits per partner of like the top 100. It's like $6 million per partner that they're making, and I think those firms have a little bit of extra money that they'll play around with and kind of go around. But it's also, what are these innovative solutions that they're building, and who is the end user of it? It's usually large corporate players. And so it really leaves kind of this huge divide in there. So to say, hey, they're doing creative things in law and these law firms are doing that, I think it isn't a complete picture, because the typical salary for a lawyer in the United States is between $50,000 to $100,000. And so it's a world away from $6 million. So I think, as Leo laid out, I think putting in that note would be something that I would feel very comfortable with. And I think it lays out kind of the feelings of the task force mostly.
Andrew.
I just wanted to remind everybody that Rule 5.7 deals with law-related services and not legal services. So, you know, before I'm in favor of adopting a version of Rule 5.7, but you know, before we start talking about it like it's the best thing since sliced bread, the A and ATILs is not for access to law-related services. It's for access to legal services. And so I think 5.7 addresses a very, very, very tiny percentage of what we're here to do.
Okay, Mark, can you repeat what your motion is?
The motion is that we recommend to the Board of Trustees that they, as part of our recommendations, that they consider adopting Rule 5.7 and appoint a commissioner study group to consider the rule in light of access to justice considerations.
Second.
Second. Sorry.
Okay, it's been moved and seconded. Further discussion? Ready for a vote? Mimi?
All right, Andrew Rita.
Abstain.
Simon Bobby.
Abstain.
Tara Bird.
Abstain.
Judge Wendy Chang, Abhijit Shaban, Jean Clausen, Johan Trollhagen,
Yes.
Margie Estrada, Lori Gonzalez,
Abstain.
Bridget Granny,
Abstain.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Abstain.
Kevin Moore,
Yes.
Heather Morse,
Abstain.
Joyce Raby,
Abstain.
Toby Rothschild,
Yes.
Alan Rodriguez,
Abstain.
Dan Rubens,
Yes.
Mark Tough,
Yes.
Angelina Valverde, and Joshua Walker.
Yes.
Did it pass?
All abstain.
Yeah, Steve is in as well.
Okay, so it passed. That then takes us, was that?
Abstain is a no vote, it's a non-vote.
A non-vote,
Doesn't
right,
count towards
that's
the
over
vote.
here, a non.
I guess if I wanted to, I guess it's too late. Because I would have, the abstain I thought would count in the negative.
Yeah, I thought the abstain was the same effect as just.
Abstain means I'm not voting, and therefore it doesn't
Right.
count as a vote.
Can I have a
Either
motion
way.
for reconsideration? And then we can redo it?
The mover and second want to allow a revote, I think.
Johan
Anybody-
and Joshua.
Somebody who voted in favor of it, I
Successful.
believe, can ask for a motion for reconsideration, but I don't
Yeah.
think if you didn't vote for it,
You can ask for reconsideration.
you can ask for reconsideration.
It's kind of like
Who's
saying
the
that
mover and
Brexit-
seconder? Do you care?
If you want to have revote, go ahead.
Okay.
I'm sorry.
It isn't worth it, really.
There was something that Leah mentioned about the equity piece of it that I
Yeah, that's-
feel more compelled by than
Yeah.
the access to justice language that Mark had originally said. So do you mind, could we restate it or a friendly amendment to add the equity piece of it? Because to me, that's the more compelling part.
Say that again?
Can you summarize that a little bit?
I think you said it so well, yeah.
If you can repeat
repeat your motion.
Oh, I can repeat.
Okay,
The motion is to recommend to the board that they consider adoption of Rule 5, a version of 5.7, and appoint a working group to do the wordsmith.
But you said something about
It was
access to
something about
justice.
access to justice.
Oh, that's right.
We were drafting
As
bodies
a
to
means
develop,
of, in a means of
develop a rule in light of
narrowing the access to justice
standards.
gap.
Yes, that's what he
Okay.
said, but.
So I would I think it could be very easily amended to say, access to justice and equity, but that's like a word that we're not defining, but equity considerations. It's both. Because I do think, even though we may not fully understand it, I do think there is a nexus potentially to access by increasing opportunities for innovative partnerships. That's access. And then there's equity and parity. You say it's not only big law. I feel like my anecdotal sense is it's very rampant on that side, not really benefiting the people law market yet. So that's the equity part of it.
Do you mean economic equity, Leah?
I just mean equity in opportunity and access to that type of innovation. So maybe economic equity, and I mean regulatory equity, in that it seems like there is this whole area that I know the state bar is not currently regulating. For whatever reason, we don't have entree, we don't have a window, we don't have a vehicle for regulating. I'm not sure why, but I don't hear of us regulating ALSPs and their relationship with law firms.
Yeah. It might serve the function. I think what we're trying to get at is it can narrow the gap in innovation between corporate law and people law.
Yes.
That's right.
That's essentially what.
Yes.
Yes.
Let's wordsmith it. Narrow the gap in innovation between corporate law and people law.
Yes.
Yes, the white paper. Okay. Do we need further discussion? So long as the motion includes that language, that it's both for access to justice and as well as to narrow the gap in innovation for people law versus corporate law. That's the motion now. So Mimi, let's try again.
Hang on, do need official mover and seconder, unless you want the same mover and seconder.
Are there friendly amendments?
Friendly amendments.
Okay.
All right, Andrew Rita.
Yes.
Simon Bogey.
Yes.
Tara Bird.
Yes.
Judge Wendy Chang, Abhijit Sivan, Jean Clausen, Johan Droshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Abstain.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Brady,
Abstain.
Toby Rothschild,
Yes.
Ellen Rodriguez,
Abstain.
Dan Rubin,
Yes.
Mark Tough,
Yes.
Angelina Valverde, and Joshua Walker.
Yes.
All right, thank you very much.
Just a quick question, when people abstain, it passes with 50% of the voters, not 50% of the task force, or I guess that was.
Yeah.
Correct.
So an abstention is as if you weren't even here in the room.
And so we only
Cast a
need,
vote.
Doesn't even kill us.
so we only need half of the people who vote.
Exactly.
More yeses than no's.
Okay.
How about quorum amendment?
Those amendments.
Not that it matters, just.
Still don't.
The quorum relates to how many people are present in the room.
Able
Simon, we vote doesn't require.
I'm not used to all these.
More yeses than
Yeah.
no's.
In business, we don't.
You waited till someone goes over here and then
version of Robert's rules. No, it doesn't work like this at all.
I'm joking.
Yeah, an abstention is like voting present.
Oh, okay.
Well, I said that
Accusation of elitism.
I admitted that my paragraph writing was insufficient to qualify for the passage of it.
Mine, I don't think mine is. And I think you made that suggestion for better. So you owe me one.
Okay, if we can hang on for just one more item,
Seems to be
we
right,
are
that's
down to
why.
the advertising rules. Where did Mark go? Restroom. Do we need a restroom break?
Yes.
Okay, let's take a restroom break, 10 minutes. We gotta get started and then hopefully we can finish this up well in advance of 4 o'clock.
If we finish early, we can revisit 5.4, right?
I'm gonna need examples of that, Andrew.
I just want to point out that is not my suggestion and I would say no to that.
Okay,
That's really big.
we're on our last agenda item, so hang on. Before we go there though, let me just say, Bridget unfortunately has to leave us because she's got an early flight. And I just wanted to say how much I appreciate everything that she has done, particularly with these local summits. I mean, and the fact that she's holding one with the consumer attorneys. Some of you have been at some of these events where we've heard from them, and I think the education process and talking through with them what we're trying to do and how we think we're going to get there, I think is so important. So, Bridget, one more round of applause. Thank you. Okay, we are now on agenda item 3. Mark and Kevin, the floor is yours.
So, we have never taken this up before, but it is part of our charge that we look at the marketing of legal services and the communication of the availability of legal services and lawyers to consumers and matching services and things of that nature. And so it's just as a very short backdrop, the rules of professional conduct have historically been very restrictive on lawyer advertising marketing, mainly because of the ability of lawyers to be overly persuasive, to engage in overreaching, to be a little bit deceptive, and so the whole paradigm was protecting consumers from lawyers in getting information about legal services. And so that has been the driver until recently. I was personally involved in the effort that got the ABA to completely modernize the model rules in 2017 to not only update them, but to recognize that in the age of technology, and particularly the internet and social media, that the barriers to the delivery of information about the availability of legal services had to change and had to change dramatically. And so simplification was the order of the day. We had 5 rules before. We now have, the ABA now has 3. And through the efforts that a committee that I chaired through the Association of Professional Responsibility Lawyers, we went out with a survey to all the regulators in the country about the enforcement of the rules and how workable they were. At the end of the day, we came up with several reports saying, you got to go back to basics. And the basics is that any rule of lawyer advertising today should focus primarily on truthful, non-misleading communications in whatever media you want to use. It could be Twitter, it could be anything. And so that carried the day. The ABA in December 2017, through its own ethics committee, picked up our recommendations. They changed their rules to have 3 basic rules. The first one is the overarching rule, which deals with false and misleading communications. And whatever you say, however you want to say it, through the internet, through letters, through phone calls, through in-person communication, what have you, has to be truthful, non-deceptive. That covers the landscape. And some people thought that's the only rule you need. You don't need any other rules. It turns out, well, you do need another rule because you have to deal with what's called solicitation. And solicitation historically, again, from Supreme Court case law, has prohibited an absolute prophylactic ban on lawyers doing direct, in essence, face-to-face pitches for legal business. It harkens back to ancient law involving champerty, barratry, maintenance, and all those things, stirring up litigation, and also engaging in overreaching and being overly persuasive to the poor, innocent consumer about hiring you and inducing them to engage in some legal lawsuit they may have no clue about. So the Supreme Court has said it's okay to prohibit that. And so aside from general advertising, there's a second rule which deals with solicitation, and there is still a ban. The new rule narrows that ban substantially. So it really is face-to-face or live telephone. Or we left a little comment in the rules about if technology comes to the point where there's another substitute for direct face-to-face communications where the consumer doesn't have an opportunity to reflect, that could be within the prohibition itself. Otherwise, forget it. The old rule was it would apply to live internet communications. Well, that's ridiculous. Chat rooms and things like that, gone. And so that's the little ban. The other part of solicitation that is within this second rule deals with targeted communications. So it's not like I put out an ad saying, I specialize in family law, and if you have a need for me, here's who I am, here's my background. That's sort of just general marketing, general advertising. Targeted mailing is where I understand that you have a legal problem, and I'm reaching out to you with specific targeted communication. It could be in writing, it could be verbal, saying, I understand you just got arrested for theft, and by the way, the penalty for theft is like 4 years in jail. You may be concerned, you ought to hire me, that kind of thing. So it's a targeted communication. There's a heightened risk there that I may be engaged in overreaching and being overly persuasive. So there are limitations on my ability to engage in direct targeted communications under this second rule. I can do it, but I can't do it, for example, if number one, you tell me, forget it, don't talk to me. I can't continue my communication. I can't do it if the delivery of that communication is overly intrusive. It invades your privacy, or I'm taking advantage of somebody I know is in a weakened mental or physical state. I can't do that. So there are limitations on direct targeted communications that are not restrictions on general advertising. There's a few other restrictions there as well. So those are the two rules. That's all you really need. However, there are some special rules that fall in the middle. So there's a rule in between those two types of communications that deals with special situations. And so the ABA modernized their rules in 2017 to have 7.1, 7.2, and 7.3, and they're in the middle. Where's California? California, as you know, was never an ABA model rule state until November of 2018. And on the commission that we were on, the best we could do at the time is to sort of get us out of the old way of regulating lawyers, which was really awful, and into the model rule formulation of lawyer advertising. So we did that. And so we have the model rules 7.1 through 7.5. That's the older version of the model rules before they changed them in 2017. What should we do? I think part of our recommendation is, because of access to justice, and by the way, these reports I thought were very convincing that consumers need more, not less, information about lawyers and the availability of legal services, as long as they're truthful and non-deceptive. So we should re-examine our current advertising rules with that in mind, because our current advertising rules keep some of the old restrictions that the ABA has now done away with. Now, in fairness, not too many states have picked up the new ABA model rule. There's about a handful of states. Some states are looking at it. Some states go a bit farther than the ABA rule, but really, we would be one of the early states that would join in on the new modernization of lawyer advertising. The recommendation that Kevin and I are making is, again, we're not drafting the rule. This is an example where you actually could take the ABA model rule itself and say, we like that, please adopt it. We can make that recommendation if you wish. But our recommendation is that advertising and solicitation needs to be looked at afresh in light of the charge that we have, and whether or not through the social media in particular, that consumers who are used to getting information through the internet, through social media, and what have you, we need to accommodate that by loosening the lawyer advertising rules to accommodate that and adopt the ABA model rules in that regard. So that's the advertising piece of the puzzle. Now we get to lawyer matching and referrals. This gets a little bit complicated. Let me just say, we've talked a little bit about the Legal Match case which came down in this last month or so. That deals with the distinction between lawyer referral services, which are highly regulated, and to qualify, you have to meet the certification requirements and be certified as a qualified lawyer referral service in California. And non-lawyer referral services that do engage in matching activities like Legal Match. There is a growing consensus that that type of service that is not regulated is beneficial to consumers, assuming they're not false and misleading. So you have a number of commercial outlets, portals, where lawyers can sign up, and this company, which is a non-lawyer outfit, can reach out to consumers, invite them to present their legal issues, and then make a recommendation about contacting a lawyer or a group of lawyers who have signed up to be a part of that service. That's basically what Legal Match is. Legal Match is in trouble today because we have a statute, and I'm very familiar with 6155 because I was involved. It was a big fight we had years ago with the state bar, because at that time the state bar was more concerned with restricting the right of lawyer referral services to be engaged in matching services for two reasons. One, consumer protection, again, making sure that consumer got accurate information and that the LRS was qualified, met all the standards and all the protections to be certified. And number two, quite frankly, because bar associations are engaged in lawyer referral services and make a certain amount of revenue from that and perform a very valuable public service through bar associations. So for those two reasons, 6155 was amended about 1994, as I recall, to make it more restrictive in terms of what a lawyer referral service activity constitutes for purposes of certification. And what they did was, you have to stay with me for a second here, there's always been a constitutional right of lawyers to join together as a group and do group advertising. You could not prevent that from happening. So in the old days, and I represented R.W. Lynch as one of the companies that would pool, say, 4 or 5 solo practitioners, or maybe 10 of them, and they put out a single TV ad. And that is recognized and is permissible under the code. You can't, under the First Amendment, you cannot prevent that from happening. But the state bar got the legislature back in 1994 to narrow the definition of what is a matching service, or what is a referral, so that it's very narrow. So it's the act of the referral. So if you're engaged in the act of the referral and you're a joint lawyer advertisement, you could do it only if you listed every single person that's part of that advertising group, which made that prohibitive. You can't do that on a TV buy, you couldn't do it on a radio buy, you couldn't do it on a billboard. So it really curtailed joint lawyer advertising as an activity. Fast forward to today. Legal Match got in trouble because they have a matching system where lawyers, as I say, can sign up and they get a geographical area. And there's only so many who can qualify. They don't let anybody come in. And the consumer would present their legal problem, and they would then say, okay, thank you that you're in the family law area. Here are 2 or 3 lawyers in your geographical area, and here's how to contact them. The Court of Appeals said, that is a referral. And you're in violation of 6155. You're not a certified lawyer referral service. Therefore, this lawyer who signed up with you and who never paid you for being on your system, you can't collect the money from him because you're not in compliance with the law. So that's the status of that case. It's on appeal. It's being appealed now to the Supreme Court for a petition for review. So we don't know what the final outcome is, but it was decided solely on the basis of interpreting a statute. Now, switch gears. Look at LegalZoom. LegalZoom gets to do what it does without worrying too much about the Legal Match system, because their system is a little bit different. they are more like a prepaid legal service, or prepaid group, so that they can qualify to provide referrals and a little bit of legal assistance because the consumer signs on and pays a fee to be a part of that system. So they fall within this other constitutionally protected system of prepaid legal services and prepaid legal service plans. So that's what they do. Third category, lawyers. Now, California is one of the few states that allows for pure referrals. In the ABA jurisdictions, if I'm a lawyer and I want to refer a case to you, for example, in exchange for you paying me a referral fee, I have to take on responsibility for that case. Either I've got to take on responsibility for the whole case, or my fee has to be commensurate with the part that I do take on for that case. So I can't just do a pure referral. California, for public policy reasons, has always allowed for pure referrals. So what does that mean? That means we have law firms in California who are primarily in the business of referring business. They are, some people would call them storefront firms. They would just be, a storefront firm. They would advertise that they're the best firm in America to handle your legal matter. And the consumer would call them up, and they would have a cadre of lawyers and law firms, perhaps all over the country for that matter, to whom they would refer the cases, and they would get a sizable fee. That technically is permissible under California law, although there are reasons to go after them if they're engaged in fraud or misleading activities. But you have this dynamic. So lawyer referrals and matching services is a very big topic. It's got a lot of pieces to it. And our recommendation is that it should be included in our recommendations. I think Kim and I agree that the state bar should seriously consider adopting the current version of the ABA model rules, and should take a look at this lawyer referral activity, both in terms of matching services, prepaid legal service plans, and lawyer referrals. And we don't have the answer to what that should look like, but it is part of the access to justice issue. And I think as a policy committee, I think our recommendation should be that should be the next step. Someone should be, I haven't got the right recommendation yet, but they should study those three areas. And that's our recommendation. Lori.
So I just want to make sure I understand the idea is to relax the prohibitions on how lawyers can advertise. Is that generally the consensus?
I would turn around and say to enhance the ability to give truthful and not misleading information to consumers without at least a non-construction.
So that sounds like marketing to me, and I am always going to be in favor of marketing being done by professionals and not lawyers who train themselves to do that. So I think if the general idea is just changing what lawyers are allowed to do in terms of marketing and that sort of thing, so that it's less prohibitive, I'm all in. I just want to make sure that that's what the general idea is.
Yes.
As long as they don't tell lies, I'm with you there. We're good.
Randy.
I kind of think we should take the lawyer referral service stuff separate from just the general advertising solicitation. And I think hopefully it's available to the presenters.
It is.
The one addition to the history that Mark gave is that, as he correctly noted, the statute for lawyer referral services was revised, and it was revised to define a referral activity and to have the carve out on the screen there what is none of the following. And just so you understand why the bar advocated for that change with the legislatures, because the original formulation of it was if you called yourself a lawyer referral service, then you were required to comply, which led the folks who didn't want to comply to call themselves something else. And so the approach to try to close the loophole was, well, we better define a referral service activity, and if that's overly broad, then we'll include the carve out. So that's where we ended up where we are today.
Okay, so if that was a friendly amendment, I'm not sure that we have a motion on the floor. I take it, Mark, your first motion would be that we should adopt the new lawyer advertising rules
Yes,
from the ADA?
yes.
And is that in lieu of the ones we currently have, or is it in addition to? It must be in lieu of.
It would be in lieu of, yes.
Okay.
Just to clarify, it would primarily mean that you would eliminate rules 7.3 and 7.5 as separate rules.
4 and 5.
But 7.4 and 7.5 as separate rules, but incorporate them into 7.2 and 7.1 respectively. The substance of those rules get incorporated into the first two rules. So you're streamlining in that regard. And then you're eliminating the, live or real-time electronic contact with a person is going to be eliminated. So that would broaden the ability, say, perhaps, on social media or some future type of electronic communication that might be available. What's only going to be prohibited in terms of solicitation is what's referred to as person-to-person communication, live, in person, or live telephonic or video phone.
There are some other details if you want me to tell you about that, I will, but there's some other exceptions. We have for the first time ever, it has a definition of what a solicitation is, which has never been in the rules.
But we have it already.
You do, yeah, you do, but this could be even more narrow. But
well, I think the point here is that everybody wants, I think, to have the substance of what they're voting on in front of them before they vote on the actual final text. But I think this was another sort of in principle type vote, is do we want to go forward with this? Randy, you were going to say?
I don't know if replace is the best word, because we do have things in the California rules that was considered by the Sondheim RRC and affirmed, that was considered by Justice Edmund RRC and confirmed. And an example of that would be the advertising standards that operate as presumptions concerning the burden of proof. Right now, we don't have any standards, but we have the court's authority for the Board of Trustees to adopt advertising standards, which I think is a good thing. And you shouldn't be lost in this exercise of quote unquote replacing the California rule with the ABA rule. And I hope it wasn't intended to just say we throw out everything that's unique to California.
No.
Joanna.
Well, I'm not opposed to that. I really am struggling with the advertising rules being tied to access to justice issues, which we're talking about here. I'm not seeing the connect. And I think we should do it, but I'm not sure that this task force should be the one recommending it unless we can more persuasively tie the changing of the advertising rules to an access to justice issue. The lawyer referral rule, on the other hand, I see a benefit to that because it gives more consumers an opportunity to know the proper attorney they should be seeing. So I see a distinction between the two.
Mark.
The report that the committee I was on wrote for the ABA went into great detail about the access to justice aspects of lawyer advertising and the need for these rules to change in order to afford the ability of lawyers to get more information to consumers about the availability of legal services and their own availability, which is being restricted. So one of the findings in the surveys that we did was that consumers don't know how to find a lawyer. They don't know who is a lawyer in their area. They don't know enough about where do I go to look to find a lawyer. And so these rules would enhance the ability through all forms of media to let consumers know that there are legal services available in various ways and who specializes in what areas and what have you. And principally through the internet, which was very difficult to use as a vehicle to communicate lawyer advertising because of all the restrictions that the rules require in terms of disclaimers, identification of who the advertising lawyer was, and other things. So it was passed by the ABA primarily as an access to justice issue.
Was that before Google existed?
Before what?
Google. between Google and Yelp, I'm not sure how lawyer advertising opening up is gonna really improve that any better. So,
I would say it's really social media. A lot of advertising and communications, especially peer-to-peer advertising, where a client you have gives you a positive review or talks about the work that you provided. Social media is where it's at. There's a ton of stuff happening there, and I really think that from that perspective, I think that would be a significant change. The ability to use social media proactively with customers and advertising, I think would be huge.
Alan?
I agree with you. I just think everybody's doing it already. So if we're talking about like adopting the ABA rules because it just modernizes it or clarifies that again, then I'm all for it. I don't know that it moves access to justice all that much. I think people are doing it already. I mean, there are those are just kind of like the more accessible marketing technologies available. I mean, like nowadays, you could pull device IDs of everybody that walked into an emergency room and push notification ads to them inside of the ER, right? Like, so if there's something to be done in the attorney advertising rules, in my opinion, it's like that, right? It's like, how do we keep lawyers from ending up in your pocket in an ER, right? Like, or something like that. So, but outside of that, I mean, I think stuff's already happening in social media. I think this is all just kind of happening already.
So there's Heather and Johan and Tara.
From my role is that there's still a lot of restrictions, and the ability to do anything, for instance, in LinkedIn endorsements or anything like that, we're not doing it. We're taking it out because state by state it's different. So getting aligned and having more and more states aligned with what's going on with the ABA rules is helpful when you have offices in multiple states, because right now I have to go to the most restrictive state that we're in and then apply that throughout our firm. So I think getting in line with the model rules will be helpful. But also, what's going on, I mean, lawyers are afraid to advertise. I mean, there is a lot of fear out there putting anything out. So I think there is they're very conscious of what they are putting out there, yet at the same time, it's still a barrier because it's so watered down because of the fear of people coming at you. And it really is the consumer. It's not so much the corporate law, but because of the rules are being based on lawyer to consumer or sort of B2C, so we really need to help and give them the help that they need and the guidance. So, aligning with the model rules, I think would be very helpful.
Yeah, and if I could just respond quickly, I agree. If adopting the ABA rules just kind of brings uniformity, I think that's fine. But I just want to be clear, like I know people have made an access to justice argument here. I don't see it on my end, but I'm all for uniformity and making it easier for people to understand what they can and can't do.
Johan?
First of all, let me say Alan's example was in no way an exaggeration. That's a very real thing, and there is much, much more and worse and more accurate things going on out there. What I want to say about that though is I don't think this rule is the appropriate venue or way in order to control that, only because there's active pursuit of all of this right now with groups of AGs and at the federal level and that type of thing. And frankly, I just don't think it wouldn't be a bat that we could swing from the bar level. But you're exactly right.
Tara?
Never mind.
Mark, maybe for our next meeting, you could provide us all with the materials that were distributed in connection with the ABA proposed rules, including the justification that you mentioned with respect to the impact on access to justice.
We can do that.
Do we need a vote on this in principle? I hear everybody around the room saying nobody seems to be particularly opposed to it and would be open to considering this, and maybe getting the text in front of us is what we need to do. Randy, does that make sense?
For the advertising solicitation part.
That's right. Okay, then I don't think we need a vote on that today. The next question that, thanks to Randy breaking it out separately, is this question about referral. Mark, your motion on that is?
For the want of a better way to say it, it needs to be studied. Let me put some meat on those bones. Part of the rule that's got everybody concerned today is in the advertising rule 7.2b. 7.2b deals with referral fees and restricts them to some extent. It is not permissible to pay anyone for referral.
Is that model rule 7.2b? That's not.
It's a model rule 7.2b. We have to say.
It's not our 7.2.
It's ours too, yeah. We picked this up in the model rule. It's the same as the model rule. But it prohibits a lawyer from compensating, promising, or giving anything of value to a person for the purpose of recommending or securing the services of the lawyer or the lawyer's firm. And then it has a series of exceptions. And we've seen in real practice that prohibition is being challenged and questioned whether or not, as I've just said, is there something wrong? I'm just throwing this out for discussion. Is there something wrong with me paying someone to provide business to me if I can provide them with competent legal services that they were not getting before? We allow peer referral fees lawyer to lawyer, but I can't have a non-lawyer business enter into an agreement with me. I'll give you business, you give me your business, and we'll have an exclusive arrangement, and we'll market ourselves together. And for every client you give me, I'll give you something of value, whatever that may be, and you'll do the same. That would violate this rule. And so the dynamic of promoting legal services, there's some Arizona, for example, is very close to eliminating this provision from its rule as an access to justice remedy. That's a very debatable topic. There's a lot of pros and cons there, but I don't think our commission can solve that dilemma other than to say it is part of the referral fee system. It needs to be looked at. So we're recommending that be studied. We're recommending that the matching issue be studied in terms of 6155. I understand we're not going to talk about the case itself because it's not final yet. It's still in the process of being litigated. We don't have a position on the case, but I think lawyer referral service activities and whether or not they should continue to be regulated to the extent that they are should be considered. Given the fact that there's so many activities out there, not just Legal Match, but others that are doing pretty much what a lot of certified lawyer referral services do. And by my research, and I had Andrew give this to me a little while ago, there aren't that many certified lawyer referral services in the state of California. There's actually quite few. California is unique in that you can't have a for-profit lawyer referral service as well as a nonprofit. Most of the nonprofits, as I say, are either nonprofit corporations or bar associations. And I'll leave my last comment. If we do go down this road and we do modernize the lawyer referral system in terms of referral fees and what have you, I think the bar association's referral services will be a casualty. I think there'll be some consequences in terms of their activities if we open up the field to non-bar association referral services. That may or may not be a good thing to do. But I think in this day and age, there's so much going on in this field that is part of our recommendation. That should be included in our recommendations.
Joyce.
I have a question. So I'm going to give you an example of something that we did in Florida, and I want to know how it fits within whether or not it's a referral. And So FJTC created for the Jacksonville Area Legal Aid Organization a document automation and sort of platform that also had an administrative interface and an e-commerce capacity. So when a client would come to JALA, Jacksonville Area Legal Aid, and didn't qualify for services, had a family law problem, and was willing to pay something to get the assistance of a lawyer, they could use the system that we developed to select from 3 packages. One was basically document review. A second was document review and some coaching and some consultation on document creation. The third was document review, coaching, plus I'll go to court with you and hold your hand. They all had different price points, and one of the conversations I had with Jacksonville Area Legal Aid as a tech development company was, you know, instead of you paying me to develop this software, what would be really great is, can I get a piece of that action? So every time somebody walks through the system, is there a way for me to get some money coming back into my nonprofit so I have a long-term sustainable way in which to continue to support, maintain, update, manage security, do data analytics, all the stuff that you do on a website. So, and he was like, well, you know, that's kind of fee sharing, and then maybe that's a referral if we're sending people to your system. If you own the system, maybe we need to own the system. And you know, I say almost 3 times every time I have one of these meetings, you know, I'm not a lawyer, but I just am curious, you know, given kind of is that a referral? Is that model possible under, are you suggesting the new rules that you're suggesting going to make that possible to do?
So the question would be, first of all, who's paying the fee? Is it the entity that you're working for or the consumer?
Well, it's going to be driven to some extent by the number of consumers that use the tool. So I mean, maybe JALA pays me, but they're going to pay me on a rate based on volume maybe, or maybe not. I mean, I don't know. Like, what do I have to do in order for it to comply?
And the second question is this consideration, you're getting this extra consideration is that in consideration for making a referral? Or are you just getting a higher fee for whatever you're providing based on how many clients they are getting on their system, which would not be referral?
Okay.
I don't hear anything that you're saying that concerns me at this point.
But that would violate 5.4.
Okay, well, I don't want to talk about that.
Oh my God, I didn't mean to do that, I'm sorry.
800-pound elephant.
Okay, Toby and then Al.
I just wanted, in response to the comments that Mark, his last comment about the impact on bar associations. A number of bar associations function based on the income from their LRS. So it would drastically reduce the ability of local bars to effectively function. And a number of LRSs, in fact, use that money to support delivery of legal services. So one of the certified legal services, certified referral services, is what used to be called the Legal Aid Society of Orange County. It's now got a new name. And I know that for many years, the Long Beach Bar Referral Service, a major portion of its income funded the Legal Aid Foundation of Long Beach. And other bar associations do that as well. So there is an impact, a direct impact, on that aspect of access to justice.
So I actually ran the LA County Bar Lawyer Referral Service for a number of years, and then I run a couple of legal directories, matching services, so to speak. I would say, based on the rules, so I'm not exactly sure where we're kind of going with this, but I would say, in general, I don't think we should split fees with runners and cappers. I think those people are bad, right? The people with the police scanners that are driving around to the apartment fire, or the apartment collapse, and then handing out blankets of, you name the PR firm, here you go, right? Like, I mean, the PI firm, that sort of thing. So I don't think we should split fees with those people in general. I think, yes, certified referral services or bar association referral services, splitting fees, like, yeah, I think it's a competitive market. I think if they want to continue to compete in that space, they have to innovate, you know. Lack of innovation was part of the reason why I left the bar association and the referral service world. And I think, like, if they want to continue to do that business, they have to innovate. So I'm a little less concerned with having to protect them when they're not doing anything to kind of keep up, right, so to speak. In terms of like the matching service, I mean, a lot of that is just kind of algorithm based. There's no human being, like say in a certified referral service, you have a referral agent who's also part of that attorney-client privilege continuum, right? That person is making an assessment as to the type of attorney you need to speak with. As where at a software-based lawyer matching service, it's making an assessment based on input that you indicated. I have an issue with my employer, so maybe that, that output is an employment law attorney, and then based on your geography. Or in some cases, could be based on your ability to pay, right? Can input pay parameters. So I think carving out exceptions for that kind of might make sense as well, but again, I guess I'm not sure where we're headed with this in terms of.
I'm not being perfectly clear. Part of the recommendation would be that this implementation group would look at 6155, which is a State Bar Act provision which defines what is a referral for purposes of being required to be a certified lawyer referral service. And we get to your point, which is the mere act of the referral within the confines of that regulation, or should there be some decision making on the part of the entity that would constitute the referral? You put your finger on the issue. The question is, it's a matter of changing this. It would have to involve changing the statute. And so, are we in a position to recommend the State Bar that they should say that the statute should be reviewed?
Yeah, Toby and Leah.
Just real quickly, the rules for LRS has recently changed to say that you can't have pure machine matches. It no longer requires a human intervention. The other thing is that there is, from a consumer protection standpoint, a distinct difference between what LRSs do and what the legal match does in terms of requiring expertise, requiring experience in the area in which cases are being referred,
malpractice insurance,
requiring malpractice insurance, a number of things like that that are consumer protection matters. So that when you get a referral, you know that you're getting somebody who's done that kind of work and who is protected by malpractice insurance, which other lawyers don't have to have. They only have to if they're part of the LRS.
I agree, and they should market that as the value add. But I think there are a number of directories like attorneyflatfee.com, maybe I think is one of them, where they've taken the time to actually show in advance what you pay for a specific service. And I think that adds value to the consumer, right? Is that like now you have predictability around pricing and things of that nature, so.
I think it's also something we can take in the, not necessarily want to refer to it, but we can take it in the sandbox too and get some data on it.
I was just going to, Toby's comment was a good segue, just to say that there's another alternative to looking to amend the statute, which is to amend the State Bar rules, not even getting at what is a referral service, but looking at our own rules, which are, even though we recently amended them, they're still pretty regressive. For example, we allowed automated matching, but then you have to, I think, do a sample of 25% of your automated matches and follow up with a phone call to see if the match was successful. But we don't have that kind of quality control on the human matching, so why would we impose it on the technological matching? So I just wanted to throw that out there, that you might want to have something a little broader than just 6155, because I think we have more flexibility with respect to our own rules, and we don't have to touch the statute necessarily. Because I don't know why Legal Match and some of these others haven't come to us to apply to be certified, or that's not, I don't want to use Legal Match, it's not a good example, but some of the others. But when I look at the rules, I think, is what we've put forward, does it really make sense, or is it overly burdensome?
Can I just respond to that really quickly? So part of the reason why they're not coming to apply scalability, right? So one of the first things I did when I went from the LA Bar to LegalZoom was I actually set up a certified lawyer referral service. But the application process took like 5 months, and we have to do it county by county. And we have to collect a lot of data and do this, right? So as we're with the tech, we can set up a web page, do some marketing, generate traffic statewide, service people. Like, we shouldn't have to physically have an attorney in San Diego County, right, to like service a San Diego resident, because that San Diego resident might have better value from a Redwoods, California attorney, right? Like, and so those are some of the reasons why. So I agree with you in that, like, maybe it's just looking at those rules.
We did change some of those rules, actually. You no longer have to submit 58 different applications to operate in 58 counties. One will suffice. And we also provided language for allowing attorneys to be on multiple panels so long as they can provide the service to the person who is in the other county that meets their needs. So if it requires them to be in San Diego, then they need to be able to have some office or other professional setting to meet with them there. But otherwise, if they can do it remotely, they can do it remotely. So those ones we did get on top of, correct.
Okay, so Mark, I have completely lost track of what your motion is. And although this has been a fascinating conversation, I don't think there was a second to your motion. So perhaps you can state it again. We'll see if we can get a second and then figure out where we go.
On the matching service issue, which is wise to keep separate from the first recommendation, that the recommendation would be that the area of fee sharing and matching services under the current rules and regulations should be re-examined in light of access to justice considerations. And that includes our rules, particularly 7.2, the state board regulations on lawyer referral services, and the matching services that we know exist that are out there.
Thank you. Is there a second?
Second.
Okay. Further discussion? Mimi?
I'll abstain and I know what it means.
Yes.
Gerber.
Wait.
It was side.
Can you restate it again? I'm sorry.
The motion is to recommend area fee sharing and lawyer referral services should be re-examined to in light of access to justice, and this would include re-examination of state bar rules pertaining to lawyer referral services, Rule 7.2, etc.
Can I just ask one question of Leah? Do we know for sure that these people have not, by these people, that there are entities, these referral services that haven't applied? Because you said that they, like, I don't know why, that is that like?
Yeah, lots of them.
Statistically, most lawyer referral services are not certified.
Right, and I feel fairly confident in saying that they have not all applied. It's not that we've denied all of them.
I find that really interesting. I guess it's a yes, but if I could, it's a too-late friendly amendment that I'd like that to be further investigated. Like, why aren't they? Because it sounds like we've addressed a lot of these issues.
Yeah,
before changes are made.
Part of what should go into this next phase is understanding what are the barriers in the current paradigm. This is really helpful what Alan said. It's something I've just been wondering. What even though, again, when you read these rules, you can imagine what the barriers are.
With that friendly amendment, I'd be good to go.
Perhaps we should start over.
That clears.
Been here before.
Okay, we're going again. Take two.
So both Mark and Toby are cool?
Yes. So the amendment is also to examine or try to understand the barriers in the current paradigm preventing LRSs from applying. Yeah, right. Andrew Ruda.
Yes.
Well, now you change your vote. Simon Bowman.
Yes.
Sarah Bird.
Yes.
Judge Wendy Chang, Abhijit Siobhan, G. Clausen, Johan Drolshagen,
Abstain.
Marcia Serrata, Lori Gonzalez.
Abstain, and Simon offered to buy me a copy of Robert's Rules of Order.
Bridget Grandy. Andrew Kuchera.
Yes.
Joanna Mendoza.
Yes.
Kevin Moore.
Yes.
Heather Morse.
Yes.
Joyce Raby.
Yes.
Toby Rothschild.
Yes.
Ellen Rodriguez.
Yes.
Dan Rubens.
Yes.
Mark Tuff.
Yes.
Angelina Boverde and Joshua Walker.
Yes.
Thank you.
So, Brandy, What haven't we done today that we need to do?
Move to adjourn. We will work, staff will work on the assignments sent out as soon as possible after this meeting. A lot of it will just be asking the people who presented materials today, spoke in favor, who have joined those teams to refine the write-up so that we have it in a position where it's not just in principle and concept, but it's the words that's going to go into the report. And so if you have that kind of input to the teams who presented today, then just in general, send it into staff and we'll turn that around to them because we don't have a lot of time. What we've been trying to do, and Mimi, has been the one to really push this, is that once we get the work product in from the drafting team, we try to turn it around quickly to the members of the task force so you can submit email comments, and so that the thing is as well prepped for consideration and a vote if it's in that at that stage. We won't really have that much time to do it this time. So just based on what we talked about today, if you want to give language, and it's not just the language we talked about, like how do we make sure the messaging on 5.4 is correct. If you think you couldn't vote for something unless these words were there, then send those words to us now and we'll get them to the drafting team so that they're there for the February meeting. Because we really need to start voting on the very concrete stuff in order to advance the writing of the final report.
But we'll have an opportunity to see the comments still on the.
Yeah.
Yeah, but we only have 13 days after posting.
Yeah, that's why the sooner you send us.
2 weeks.
Give me time, can you give us some sort of deadline on like when things are due, when we're gonna need to have things in?
I will need it by the material 2 weeks. No, but I'd like people to have sufficient amount of time to actually review it instead of giving it to them 3 days before.
A little fun.
1, 2, 3, 4. You guys get it to me by the 27th?
27th, okay.
That's after the board's.
Yeah, it's after the board meeting, that you're 2.5 weeks.
So 2-2 or 2-7?
No, 1/27.
27,
January
okay.
27th.
That's doable, no, totally fine, I work better when I know.
2.5 weeks.
So everything you just heard from Randy is an indication of how hard these staff folks work on this. They are so busy all the time. Thank you. And thank you all for the time and energy and enthusiasm. It's been a great day. Everybody travel home safely and we look forward to seeing you on February 4th.
Thank you, Justice Edmonds.
Yeah.
Thank you.